look beyond the national boundaries, Croatian boundaries, in this respect and contribute meaningfully to the current European debate. What should the new EU public procurement beyond the national boundaries, Croatian boundaries, in this respect and contribute meaningfully to the current European debate? What should the new EU public procurement beyond the national boundaries, Croatian boundaries, in this respect and contribute meaningfully to the current European debate? What should the new EU public procurement beyond the national boundaries, Croatian boundaries, in this respect and contribute meaningfully to the current European debate? What should the new EU public procurement beyond the national boundaries, Croatian boundaries, in this respect and contribute meaningfully to the current European debate? What should the new EU public procurement beyond the national boundaries, Croatian boundaries, in this respect and contribute meaningfully to the current European debate? What should the new EU public procurement beyond the national boundaries, Croatian boundaries? I think it's safe to continue. Is it? We're going to know in a couple of minutes. What should the new EU public procurement beyond the national boundaries? No. We still have it. I think it's safe to continue. Is it? We're going to know in a couple of minutes. What should the new EU public procurement beyond the national boundaries? No. We still have it. I'm going to think it's safe to. We're going to ignore it. We're going to try to. Is it? The timing could not be better. 14 directives are undergoing revision, and the European Commission has recently published its comprehensive evaluation, followed by expert timing could not be better. Leading academics and 14 directives, some of whom are with us today. And the European Commission has of this conference, you will have the opportunity to hear that, followed by expert as well as from members of the Commission's procurement experts, whom are with us group, and the including our own Maya. This conference, you will have all of our presenters are distinguished experts in their respective fields. Academics, practitioners, policymakers whose insight, experience, and intellectual curiosity make this gather presenters are distinguished. We are deeply grateful for joining us and for sharing their time, knowledge, and perspectives. While this conference is firmly rooted in academic inquiry, the discussions we hold here and the views expressed may well influence the direction of future European procurement policy. This is precisely the spirit captured in our title, A New Way Forward. It's important to note that the discussions and the conclusions we reach here will not end here. They will be compiled and published together with a selection of papers presented at this event in a special issue of the collected papers of the University of Zagreb Faculty of Law, forthcoming in the second half of 2026. The special issue will be open access, ensuring that insights shared here reach a wide audience across the EU and beyond. I wish you all an inspiring, thought-provoking day without echoes. Exchanges, ideas that will help shape the next chapter of public procurement in Europe. Thank you.
Thank you. Thank you, Marko, for these words. Good morning, everyone. Good morning to our distinguished guests, to our colleagues, to our dear friends. It's my great pleasure to welcome you today on behalf of the State Commission for Supervision of Public Procurement Procedures as one of the organizers of this conference. Our special welcomes are going to our distinguished panelists today, but also to our dear guests in the audience, especially our colleagues coming from procurement authorities and review bodies from Austria, Bosnia and Herzegovina, North Macedonia, Slovakia, and Slovenia, as well to a number of you who are joining us online all over Europe today. We are truly honored to host here in Zagreb such a diverse and knowledgeable group of professionals, academics, policymakers, and practitioners who share a common commitment to improving public procurement systems across Europe and beyond. You are all aware that we are living in challenging and transformative times. And as Marko mentioned, public procurement is undergoing a major transformation as well recently. The European Commission is reviewing the procurement directives And for the first time in over a decade, we have the real opportunity to shape the future rules that govern how public money is being spent. Therefore, I will make this short. Let's use this time together to share ideas, to challenge assumptions, and to build a better path forward. So I wish you all a productive and really inspiring conference today. Thank you. But before we begin, I would like to take a moment to acknowledge a profound absence among us today. As many of you know, Professor Christopher Bovis was meant to be part of this conference, but his recent passing left an empty spot, not just in the conference agenda, but in the public procurement community as a whole. An empty spot he leaves behind is for sure not one that could be easily filled, and his absence will be deeply felt for a long time. Therefore, I would like to warmly invite Professor Tunde Tatray and Professor Roberto Caranta to share a few words in tribute.
Thank you very much for the opportunity. Let me tell you just a couple of words about Christopher Bovis, or Bovis Professor. You should know that at the very beginning of the century, in 2000, 2002, we had a chance to meet him. He was Chris Bovis Professor, the Bovis Professor. But after the accession to the EU, he came to our countries again, to Hungary, to Croatia, to Slovakia, Czech Republic, Slovenia. He supported us. He participated in our conferences. When we invited him to workshops, then he was the first who were talking about the reality of the power procurement market. He was against gold plating, just copy, paste the European regulation into our national regulation. When we were applying for big international research projects, he was the first who supported us and recommended us. When personally we asked recommendation letters, we wanted to receive scholarship, young researchers, he immediately helped. And when we asked his advice, he really, really suggested the best of the best for all of us. In the last couple of years, we had great opportunities for all of us to meet him and to utilize his knowledge in these occasions, events, and of course, in our everyday researches. Last time, I personally had an opportunity to participate in a defense when a lady come from Saudi Arabia made and wrote a PhD about the corruption in Saudi Arabia. You can imagine how he could support and of course, do everything for those researchers, young scholars, and of course, for those professionals coming from the developing countries. We will never forget what he did for us.
And just to add a few personal thoughts, professionally, it was great. It was not just an ivory tower professor. He was deeply involved in practice. He could really bridge the chasm between theory and practice, but he was also, more importantly, possibly an extraordinary human being. At times you have great professionals, they are very cold. That was not Chris. I just remember we were often meeting in Trier also with Maya, and he was sitting there in Villa Hugel, a beautiful setting, and just inviting everyone for a chat, a drink. He was not really the one drinking, and he was always remembering, how is your wife? Last year she had a problem. How are your kids? They should be, and always getting the right age, maybe after 1 year. And is extraordinary persona was such that he was a firefighter in Canada, but not any firefighter. He was flying Canadair into flames to put out fire in his adopted homeland. He was just so an empathic person. Okay, his family was from Cyprus. He was teaching in the UK, but he could really feel at home everywhere and make everyone with him feeling at home, valuable, and important. He really has left a wide gap in our community. So we propose a minute of silence. I know in this room, because of what was said by Tunde, there are many people that have worked with him and have memories of being with him. So 1 minute to remember the moments with him. Thank you.
Well, thank you so much, dear Roberto, dear Tunda. Thank you for these kind words. And I believe for all of us who knew, who had the honor to knew the Professor Christopher Bovis, I think the best way to honor him is to go on with our work with the same passion and the same dedication that he was putting into it through all these years. So having that in mind, we will start with our first panel of today's conference. I'll be hosting this panel since the panel is about remedies, of course. And I'm really honored to have a lineup of really renowned speakers on this first panel. So let me welcome our first panelist, Professor Karina Rizvik-Hammer from University of Copenhagen. She holds a PhD in public procurement law from Copenhagen Business School. She has been lecturing at Copenhagen Business School, Copenhagen University, and University of Southern Denmark in mainly public procurement law, EU law, and administrative law. Welcome, Karina. I'm also, please have a seat. I'm also happy to and pleased to invite my second panelist, Professor François Licheret, Director of the Chair on Public Contracts Law at the University of Jean Moulin, Lyon 3. François is a member of the Stakeholders Expert Group for Public Procurement, which has recently been renewed in order to help and assist European Commission in drafting the new and revised public procurement directives. Welcome, François. I'm happy to introduce Ms. Bojana Todorovic, a law lecturer at the University of Belgrade, Faculty of Law, specializing in public procurement and environmental law. She combines academic expertise with practical experience, focusing her research on procurement reforms and transparency. Join us, Bojana. And last but certainly not the least in this case, Mr. Michael Fruman. I'm really honored to welcome you on our panel today. Mr. Fruman is head of the Procurement Law Unit at Austrian Federal Ministry of Justice, in charge for overseeing public procurement policy, drafting legislation, coordinating international negotiations, and Mr. Fruman as well represents Austria at the European Court of Justice. Please join us. Welcome to all our panelists. And now it's time for me to finally pass this floor to Professor Karina Rizvik-Hammer with the topic of effective remedies and review systems, and trying to answer the question, what could be improved further?
Thank you.
Thank you very much. It is always a little bit tricky starting a conference after also having a few memorial words. And I just wanted to say I didn't know Chris very well. I met him a few times. I didn't have the pleasure of working very close with him. But he has a great impact on my career because he was in a very important assessment for me. And I found the assessment that he wrote very fair, but also very friendly. And I always think of him in a very nice way, and remembering that not always the ones you work close with can influence your life in academia, but also those coming from afar. And I think he at least taught me that whatever you do with all these assessment of younger scholars, you have to be fair and you have to be friendly all the time. So with this, skipping to what is, in my opinion, the most interesting topic of today. It's also the most important one. And it's, I don't think I ever been to a conference where we start with remedies. It's always something in the end. So I really appreciate the priorities here that we start with remedies. And I'm an expert member of the Danish Complaints Board too, so I also have the pleasure of looking at national cases. And when the Danish, when the implementation of the Remedies Directive in the 2007 one, I also had the pleasure of writing that piece of legislation because I was working at the Danish Competition Authority at that time. So I have sort of like a full circle, you know, you write the legislation, you have to see it in practice, and then you go back to the university and you can write a lot about what is wrong and what is working and what's not, and what could improve. So great to be a part of this topic. Yes, this is just what I thought I could say a little bit about, just a bit of an overview first, and then a few words on what is actually an effective system and what is effective remedies in general. This is just a few slides that I stole from a presentation the Commission did on the first instance review bodies meetings held in Denmark a couple of weeks ago. But just to show you that if you're looking at the number of decisions, these vary a lot in the member states. So you have someone over 3,000, someone over 5,000, and then you have member states that almost doesn't have any complaints at all. So this is just to say that it's really varies a lot in the different member states. The same goes with how long time it takes. And often we are talking about effective remedies, review system. It means it needs to be fast. My personal opinion is that not necessarily the truth. It also has to have effective solution and it has to have a proper outcome. So fast is not necessarily the right solution, but also just to show you that at least the numbers also here shows that some are really fast and some are taking their time to take the decisions. And why start with this? It's sort of like also to say that there are also a lot of national differences on this in these aspects, and I think that there should be. It's not like we want one complaint body to be hosted in Luxembourg that deals only with public procurement breaches. We need these national differences also in types of where we complained and the system. So I'm not suggesting any sort of like streamlining on this, but I think that at least from a tenderer perspective, it would be nice with some transparency and also sort of like what can we expect when we are bidding in this country? What are the possibilities and how long outcome in case we complain could we expect on these aspects? So this is just the Remedies Directive. I'm sure you know them, and the two of them, and we also have this amending directive. And in 2017, the Commission had this evaluation of the Remedies Directive, and it's a it's a nice report that sort of concluded that there's nothing wrong with the remedies directive. It's just the national measures. So it's not me, it's you if there's something that is broken. And I think that is worth taking into sort of like some consideration. That it also depends on the eyes that are looking, if there is something that could be improved, and I think there is definitely some room for that. These are sort of like just an overview of what we are dealing with on an EU level. I'm sure if you know your national system well on remedies, that you have a lot of national peculiarities that is not a part of the EU legislation, but we do have something that needs to a minimum be there, and these different mechanisms have been expanded in some member states and in some member states not. And I think that this is also showing that the practice is very much different. This is a quote from a very old case, Stadthalle, that I use a lot. I think you've seen, the direct award is considered the most serious breach of EU law in field of public procurement. And that might be true a long time ago. And when we're talking about direct award, we are thinking about this situation where the big municipality awards the contract directly without any transparency to the cousin next door to someone working at the municipality. So that's kind of like the most serious breach of them all. But today, when we're talking about direct award, it covers so many different situations that might not be so serious. It covers this wrong classification of a contract. So if you're estimating in-house wrong, and if anyone here knows, in-house is not the most easy one to measure, but if you get it wrong and you award it directly to someone that turns out not to be in-house, it's directly awarded. The same goes if it's turned out not to be a concession. If it's wrong use of an exception, you could not use it. You had to have a notice up front. It's contract modification that turned out to not be legal, and so many other situations. So maybe direct award is not supposed to be considered the most seriously breached that we have in EU law, public procurement anymore. And there might be a room for sort of like adjusting the remedies in this field. I know we have these transparency notices, the VEET notices, and they are also used a lot. And we have great examples of, publications on the 20th of December for a lot of direct awards. And then you just wait 10 days and you can sign the contracts. So in principle, they work. They create transparency, but they are also used a little bit to sort of like, let's say, wrongful uses, or they're used to be not necessarily on the safe side, but instead of actually doing a procurement. So I think there is definitely some room to look at this measurement and the ineffectiveness sanction. Maybe it's not supposed to apply for all these situations, but maybe we could figure out something else. And along the way, the court comes up with different things. Like, for example, a framework agreement has to have a maximum, and after this maximum, it will also be considered direct award. So I think that maybe direct award is not so serious anymore, and we should give it some thought how to deal with the remedies on this perspective. So what do we know so far? If you look at the call for evidence that was just published, we know that the remedies directive will not be a part of the modernization. So why talk about it and begin with it? There's probably not so much we can change at the moment, but we can at least start looking at it. And if you go back to 2011, when the Commission proposed the new directive, the directive was divided into 10 categories when they were under negotiation. And one of those categories was a governance cluster. And this governance cluster had this proposal of every member state should appoint a single independent body, an oversight body that had to be responsible for implementation of the directive, but also to sort of like coordinate procurement at national level. They should also be examining complaints from citizens. They should be issuing these kind of like red flags if they saw something was wrong. And they were supposed to be monitoring public procurement in the member state, and they were given quite some heavy powers. And there was also the idea that a lot of this should bring back data to the Commission, and there should be sanctions for all of these. And I think that if you look at this cluster, and I have an idea that you could imagine that the Commission will introduce something in the type of governance again. So maybe the remedies directive is out, but at least we would probably see something on this. And this is not something we are talking a lot about. It was heavily discussed. It was like member states did not like this in 2012, but who knows, maybe some of this will come back in. And I think that this is probably one of the sort of like main surprises that we will see. So maybe we should prepare a little bit about what could come. And I hope you know a little bit more, Michael, on this aspect. So just to sort of like overview the conclusion from the 2017 report, it said that it was it had generally improved the complaint system, and that there was some issues on the interplay between the new 2014 directives and remedies that could be clarified if we open the remedies directive, but not enough for the Commission to do so. So I'm just thinking, like, if we imagine that now we're just going through a modernization again, and we're not planning on modernizing the remedies directive, I'm just thinking that there will be much more that could be clarified in a new directive, and that we need to think about opening the remedies directive again. Many things are not that could be looked into. We have a lot of new sector legislation. We have no sort of like idea on how this works on remedies, and we have a lot of different implementation of that. In Denmark, for example, if we take the eco-design regulation that requires that tenders should be excluded from public procurement in case breaches of that piece of legislation, we have not really implemented that because we think that, well, we have a ground that says, well, if you do something serious, you can be taking away your license to do business anyhow, and then you cannot deal with the public sector. So we don't need an extra ground to be excluded from public procurement. And I think that that is wrong, and I think that's the wrong way of looking at it. But we are not really sure, and I think that we probably have different member states that look at these exclusions in many different ways, and maybe remedies directive would be one way to sort of like streamline how to deal with these situations. Inkstill case, loss of chance, I'm sure you will talk about that, Francois, but loss of chance is non-existing in Denmark in any field. So we would be happy to know if we need to sort of like do anything in this aspect. And I think that's also a good reason to look at the remedies directive. And I think there's a lot of different ways and topics that could deserve some clarification. So with this in mind, I will have set my 15 minutes and pass on the little remote to you, Francois.
Maybe I will just introduce our second panelist today, Professor François Licheret, with a really interesting topic of damages in public procurement, the so-called new concept of a loss of opportunity, ili gubitak prilike for all of you from Croatia. This is something we haven't heard so much so far in Croatia. So please, Professor François Licheret, take the floor.
Thank you very much, Maya. So I'd like to extend my thanks to both of you, Maya and Marco, for giving me the two reasons of happiness. One is a chance to visit Zagreb, thanks to you, to discover the beauty of Zagreb. And the second is to rediscover the beauty of this topic, because I touched a little bit upon this topic last April at the conference. Was it in May or April in Copenhagen, organized by Carina? The topic was a bit different. It was the impact of the ink steel case on French law. And at the conclusion, I stressed that I had the feeling that damages were not a real good way of enforcement, but there was just a feeling. So now I had a second thought about it, and it proves right that there was a famous quote of the French Ministry of Foreign Affairs, Talleyrand, at the beginning of the 19th century, who said, "Be wary of the first move. It is often the right one." And that's my actually conclusion of this topic. Now that I've been giving some more thoughts, I don't think damages are the good way of enforcing public procurement. So now that you know the conclusion in my introduction, I will try to build with you the reasoning a little bit like, I don't know whether you're aware of this American series, Columbo. He was a policeman who would actually, you knew from the very beginning the conclusion, who was the murderer, and you have to rebuild the thinking of it. So let's start with the thinking. Oh, by the way, I'm pretty radical in my conclusion that it's not a good way of enforcing the public procurement rule, which is different from ChatGPT, because I've tried with ChatGPT. And he actually has a very nuanced way, which is usually what I tend to conclude. But we have different sources. He quoted, by the way, Stuart Smith, Albert Sanchez Grails, and Christopher Bovis, by the way, whereas I quote Roberto Caranta and the late Steen Treumer. So the conclusion might be different because the sources might be different. So the topic is, are the damages the new paradigm for enforcing public procurement rule? The third thing to consider is what's new? So let's start. And by the way, I chose the picture with a dollar, which makes sense, but you understand that at the conclusion. What's new? Are the conditions for a paradigm met? Is private enforcement the only future of remedies? And some question afterwards. Of course, what's new, you all know the review directive. I won't insist on that. Article 2, paragraph 1. There should be powers to grant awards, to award damages to persons harmed by an infringement and by operators adversely affected may bring an action for damages. So we all know that. It's true that there hasn't been a lot of cases at EU level. We all know the Strabag case in 2010, the Fastnet case in 2013. I won't really build on those cases. They didn't really give a lot of details about how to implement the right for damages. And they didn't talk about loss of opportunity. In that case, what is the real novelty is the ink steel case that Carina was just mentioning, 2024, gubitak prilike, possibility, loss of opportunity for a candidate illegally rejected before its bid was even made. It was a case, it was a Slovakian case for the building or reconstruction of 16 stadiums in Slovakia. Whereby the candidate was rejected before giving any offer. And so it ended up before the ECJ which for the first time said this candidate has a right to be granted awarded. It's quite important to say that in that case, the candidate could not challenge the contract anymore, and that might be an explanation of the case. So is that really new? Well, it depends on which member states we're talking about, because there might be some member states, not the case in Croatia, I think, nor in Denmark, where it does exist. I co-edited a book in 2011 with the late Steentrömer on this, with Duncan Fairgrieve and Steentrömer and Roberto Caranta took part in this one. By the way, both authors were quoted by the Advocate General in the Ixnil case, which shows that they were the good sources. No, just kidding. But that in that case, in this book, we tried to see what was going on. And what is quite interesting is that after this book, there were quite a lot of developments in certain countries. I'm just taking the example of Portugal, which is very interesting, that Miguel explained to me. Miguel Assis Raimundo explained to me. There's been quite a lot of development, and they did some development in the case of loss of opportunity when you have one rejected candidate, where they put in place the so-called proportionate compensation, depending on the chance the candidate had to win the contract. Let's take the example. You have 4 candidates. One is excluded for bad reasons, but he couldn't make his bid. So we're not sure about he would have got the contract. So how do we do? Well, he had one chance out of 4 to get the contract. So therefore, he could claim 55% of the lost profits. That's how it works. Quite interestingly, by the way, there are cases at EU level, and there were cases before at EU level regarding awarding damages for public procurement of EU institutions. So I insist on the General Court ruling 2018, Vakakis, that's a Greek case, regarding a lost contract, whereby the General Court actually issued the same conclusion that you can claim a proportionate amount of lost profit. So it's not that new somehow. Of course, it's new at EU level for member states. Are the conditions for a new paradigm met? What I mean by paradigm, just is it a model that we can follow? Are the conditions? My point is that at least to get to be a model, you need to have a certain degree of legal certainty, which is not the case here with Ixnil. Why? First, it concerns only a rejected bidder. What if there's a direct award? Does it mean that you can claim damages in that case? You can say there's not a high probability of causal link in that case, but that's debatable, right? And the court didn't say very much about it. Also, in that case, the court said, in such a case, in particular in the case of Ixnil, there should be a right for damages. Does it mean that you need to be in a situation where you cannot challenge the contract? We don't know. They just say in particular. So in terms of scope, it's quite uncertain. What about the consequences? The court said nothing about the consequences. What does it mean? They just said we need to distinguish loss of profits and loss of chance, loss of opportunity. It doesn't mean, in my view, that you cannot claim part of the loss of profits, or even in some cases, you could claim 100% of loss of profits when you were sure to get or to be the only one to get the contract. For example, if the one chosen should have been rejected for exclusion ground or whatever. So that's also a question of scope and consequences. Well, we're not sure. I'm not sure we can think that it's a model. And I'll get back to the question of calculation in damages in Portugal or France. Oh, by the way, I didn't talk about the case of France. It's quite interesting in terms of comparative law, because in 2010, the French Conseil d'État, Council of State, the highest Supreme Administrative Court, rejected the theory of loss of chance or loss of opportunity, mainly on the ground on the protection of public money. Because they say in that case, that means there might be several candidates who could claim damages, and that might be tricky for public money. On the other hand, they have a quite generous case law by which they say you can get a full loss of profits if you had a serious chance to win the contract. Not necessarily 100% chance. Even if you're in the third position, you could claim damages. However, in the case of ink steel, when you're not able to make a bid, you cannot claim any loss of profits, even 25%. You can only claim bid costs. I'll get back to this with the question later on. Is private enforcement the only future of remedies? I think there are barriers and pitfalls for damages action. The litigation are long, years to get damages. I mean, what is the incentive for public agents or even firms when you know that it's going to take like years? In France, you got courts of first instance, appeal, French Conseil d'État, 8 years, right? You won't be in a position to take benefit of it as a personal actor. It is uncertain result. I don't think it's the main purpose of firms. When we do interview in the chair I set up in Lyon, we do a lot of interviews, we do a lot of opinion polls. We just did one on simplification with 600 answers from the practitioners. When we do interviews on those topics, the firms would say, well, we don't really care about damages. What we want is to get the contract, right? To make our workers work simply. So there are not good incentives. And by the way, there are also questions of appeal fees, not in France, but in some countries. There are questions of lawyers' fees. In the UK, for example, it's very expensive. And it makes more sense in common law systems because, as we all know, damages are the remedies by principle, while in historical aspects. So there are some systems where it makes more sense. And maybe to finish on the topic, I'm not sure about the timing, but to finish on the topic, I'm thinking of private enforcement efficiency right now, which can be questions. Is there enough incentives for competitors? So not only, I'm not even talking about damages, which is for me not really incentive for competitors, but even like interlocutory measures. Of course, they can be very efficient. However, for example, in the French context, it's like 600 cases per year. Considering the number of public contracts, it's not that many. Although in France, there are no appeal fees, so no like financial barriers. They are not very, very used. They are not very used. So my concern is that can we rely only on private enforcement? Why don't we think about some kind of more public enforcement to be added, like a little bit like in competition law? What there's so differences between competition law and public procurement law? Of course, in competition law, it makes sense because you need to make inquiries about illicit collusive agreements. But then why not in public procurement, right? So I know that in some countries like Italy, there are some kind of public organism that does public enforcement. I don't think our Italian colleagues are really in favor of those public bodies, but maybe we need to think about other ways to improve the system. That's one of our projects. We're going to lead a book or co-edit a book with Karina on this topic, and I'm thinking of trying to find grants from the EU so that we can compare what are the real barriers. It's good that you have, for example, review bodies, but what if the people don't challenge? Recently, a partner of my chair said, we're going to be rejected for abnormally low tender. In public works, with a firm who is really knowledgeable, it's quite strange. So I said, you could challenge, you have plenty of opportunity to challenge legally. They said, we won't, simply because it's our best client. So we won't challenge it, although it's quite obvious it's illegal, we won't challenge it. So that's some thought that I wanted to share with you. I had other thought that I wanted to share, but I will keep them for the questions. Thank you.
Well, thank you so much, Professor Lecher, for this interesting topic and insights, because the loss of opportunity concept is definitely something that will need to be addressed a bit more in future in Croatian case law, I guess. And now I would like to ask Ms. Bojana Todorovic to join us for her intervention. The topic is ensuring the sustainability of public procurement through the availability of legal remedies to representatives of the civil society. So extending again the legal standing in some way.
Thank you very much, Maya. I would first like to wish everyone a good morning. I'm really excited to be part of this conference, and I would like to thank the hosts, Maya and Marco, for their invitation and their warm welcome. I would also like to say that I feel quite privileged because in a way I had two introductions. One was from Maya and the other Professor Lecher, who basically paved the way for my presentation when he raised the question, I would say still an open question, is private enforcement the only way forward when we talk about the reviewing the remedies directives? Now, I wouldn't say that it is the only way forward, but I think it is an important way that we need to consider, and that is what my presentation is about. As you can see from this long and seemingly complicated title, this topic lies at the intersection of sustainability, public procurement remedies, and civil society. So in a way, I make an attempt to integrate these three fields. Looking at the title of the presentation, one might pose the question why it isn't part of the, for example, sustainability or the strategic panel, but I think the organizers made a strategically good choice to place it at this, to make it part of this first panel for at least two reasons. One of them is because the adrenaline is helping me wake up in the morning, which is not so easy considering the weather. And the second one is, well, related to something Karina said as well. I think this topic of remedies is extremely interesting and extremely important. And I have to say that I'm also, since this is a work in progress, I'm very happy to hear that there are representatives of review bodies from the region here. And I hope to get insights from that perspective as well in streamlining my research. Just a few words on my researcher positionality, because Maya mentioned that I'm a lecturer at the University of Belgrade, Faculty of Law, and she mentioned practical experience. My practical experience is not from the position of someone who works at a review body. I work for a contracting authority, and currently I'm involved in procurement planning, which will become important at some point of my presentation, and you will realize why I consider this a particularly important phase of the procurement cycle with respect to this topic. And given my workplace, I didn't have to go very far in finding inspiration for my topic, fortunately or unfortunately. Here in this first slide, you can see how a very high scale or high-profile infrastructure project Expo 2027 has been envisioned. So basically in 2027, Serbia will host a specialized Expo exhibition in Belgrade, a 3-month high-profile global event, which is focused on innovation, among other things. One would expect such a large infrastructure project worth billions of euros and implying the construction of a number of supporting facilities, such as a national sports stadium, or a railway infrastructure, to be under particular scrutiny due to its economic, societal, and environmental impacts. One would be terribly wrong. This project is being developed on the basis of a lex specialis that not only completely circumvents the public procurement legislation in place and the underlying procedures, including review procedures, review mechanisms, but it also abolishes the requirement to conduct prior environmental impact assessment and even enables investors to start using buildings before obtaining the required legal permits. Of course, all of this without properly conducted public consultations and against the backdrop of the largest anti-corruption protests in the country's modern history and a systemic rule of law backsliding. That is where the irony of it all lies. The described scenario might sound shocking to someone outside of the Balkans, where public authorities bypass established public procurement legislation, including transparency standards, competition, legal redress, etc. However, it has become a tradition in Serbia, where I come from, but unfortunately also in countries of the region as well. And this helped me gain more inspiration, so to speak, because doing a little bit of research, I realized that there are similar projects in, for example, Montenegro and Albania. All of these high-scale projects implemented on the basis of something that was also mentioned in the first presentation, sort of an excessive or extensive way to interpret exceptions in the implementation of public procurement legislation. So based on either a bilateral agreement or a special law focusing on that particular project, that, like I said, completely circumvents public procurement legislation. I don't need to go into much detail to tell you what the repercussions of such an approach to large-scale infrastructure projects are. One of the most detrimental and one of the most painful to someone coming from Serbia, of course, being the collapse of the canopy of the railway station in Novi Sad. Now, the question I asked myself, that I keep asking myself is, in such scenarios where institutions are either weak and or not interested in assuming their competences, or in other words, if public enforcement mechanisms do not function properly, if economic operators or investors are not motivated to rely on oversight mechanisms, so to instigate proper oversight, who then will ensure that such projects are developed in accordance with sustainability criteria, so in accordance with environmental and social requirements? And this is where I believe the role of civil society comes into play. Now, I would say that the role or the upside of, again, coming from Serbia and having this vast source of inspiration doesn't only come with a negative aspect, but a positive one as well. Because based on my personal experience that I've been witnessing in the past years, especially in the past year, but also after having done research for the book that was presented yesterday and that I co-edited with Professor Caranta. I was impressed and particularly motivated by the impetus of civic action and by the effects of organized civil society, including in public procurement. And I think we're all here, anyone involved in public procurement is aware of the fact that one of the hot topics in procurement is the role of civil society. And it has been recognized, it's not very controversial or new, that civil society are recognized as important stakeholders. National legislators are nudged, to say the least, by economic international institutions to sort of modify their legal frameworks in order to enable civil society to at least have a say in the policy-making process. However, in order to conduct this role of watchdog, of public procurement watchdog, which is particularly prominent when talking about the fight against corruption in public procurement and also ensuring the integrity of public procurement processes, the only way for civil society to conduct that role is to have timely access to information, to participate, to be involved, actually, and be enabled to participate in substantial changes to national procurement systems. And one of the ways this is done in comparative law is by relying on instruments such as integrity pacts. And also, there are comparative examples where national laws provide for an explicit legal mandate in order to involve civil society on a more or less voluntary basis. However, I believe that voluntary involvement, coupled with equally voluntary involvement of sustainability criteria, so the lack of an obligation upon the contracting authorities to involve civil society representatives, to provide them access to all information, to actually cooperate with them, which yesterday at the discussion following the book presentation we've seen is a huge problem in the region. I think is problematic in national systems with weak institutions and a hostile environment towards the civil society. So this is why I believe it is important to go beyond this consultative role of civil society and to start thinking about the possibility of enabling them to have legal standing in public procurement oversight mechanisms, in the review systems. I mainly draw inspiration, well, my initial idea to start thinking about this topic was based on the Serbian experience, actually, believe it or not. In our prior public procurement legislation, we actually had a legal institute called the civil supervisor, a representative of the civil society, an individual or organization that had to be involved in the tendering process for procurements above a certain financial threshold. Now, this mechanism that I believe was quite visionary and that formally was inspired by the Polish legal solution, but after having done some research, I realized that it had nothing to do with Polish legislation and that the actual inspiration might have come from the Mexican example of social witnesses involved in similar oversight of procurement processes, the Philippines as well, but definitely not from the EU, because having done research in that field, to the best of my knowledge, there are no comparative examples. And this institute didn't stay for too long in our legislation, officially because it turned out to be inefficient. But I think we need to raise the question why it was inefficient. And I believe that that is the case because civil society representatives were doing their job with limited resources and in a hostile environment where the institutions were not cooperating. However, the institute itself, I think, is a good starting point to consider the possibility of providing a legal standing to certain representatives of the civil society. And this is where I come to the remedies directives and the public procurement review system. And I think there are several important questions we need to ask ourselves before actually delving into this. To use the words, I will also quote Professor Caranta, and in a book he co-edited with Willem Janssen, they speak about a paradigm shift in public procurement. And I think this, considering the involvement of civil society in review systems in this way concerning, in order to enable sustainability criteria to be properly enforced, I think it requires a little bit of a paradigm shift. Now, one of the crucial questions is, who should we enable access to review mechanisms? Civil society is a broad concept. We have formally organized NGOs active in the field of environmental law, for example, that already have access to important legal instruments thanks to the Århus Convention. I apologize, I will try to wrap up. So that is the first question. The second one is, what exactly should be reviewed? We need to think about what decisions of the contracting authority and what the scope of this control would entail. And an important question that I hope we can discuss and develop more in the Q&A session: what phase of the procurement cycle? And I believe our focus should be on the planning phase, due to the fact that in most of these cases that I mentioned in the beginning, in these practical examples from the region, it is the planning phase that's the most problematic, and also a phase in which a lot of public procurement contracting authorities with support from public institutions decide not to implement public procurement rules. And do I have time for a final thought? Just to be clear, I was talking about national examples, examples from the Balkans, in the context of this topic. However, my research interest currently is on the public procurement review system at the EU level, and I hope later on we can discuss more about why I consider this particularly important and why this top-down influence of the remedies directives on countries that are in the process of EU accession is particularly important and shouldn't just be left to the national legislators. Thank you for your attention.
Thank you so much, Bojana, for this interesting insight. And Mr. Michael Frumer is bringing our next intervention on the topic of reform of the public procurement directives. What about remedies system, answering our constant question, I would say, of today's panel. Take the floor, please, Mr. Fruman.
Thank you, Maya. Thank you, Marco, for inviting me. Marco asked me to be the wild card, the disruptive element in this whole presentation. But before I want to start with my presentation with 4 preliminary remarks. First of all, a consolation to Bojana. The example you gave, you know, creating a specific piece of legislation, exempting a huge infrastructure project, that's nothing new to Austria. We did it, 1996, where they created a new capital in a region. Jesus Christ, we just entered the union. No procurement, forget about that. Creating a new law saying, is this exempt? So this might reflect a thinking of a famous strategician from 17-something, Prince Eugene, who said, The Balkan starts in Vienna, exactly in the 3rd district. So we are in the same boat. So the second preliminary remark, it was already mentioned, the evaluation report from the Commission. If you're really interested in, look closely at it. Yeah, look at, for example, table 4 in the annexes. 280 pages. I know it's a long thing, but table 4 is interesting. It lists there the cost-benefit analysis. And one interesting thing is, if you look at the table, and there is one slide saying, okay, remedies. And you look across saying, costs €0, €0 for contract authorities, for contracting entities, for the state, and so on, which I find interesting. Why is this exempt? Because looking before 1989, there was no remedies directive. So where are the costs living there? Huh? So the Commission couldn't answer that. The third thing is, we're looking at the remedies. The remedies are there to enforce the material rules. The underlying problem is, and the question is, if the underlying rules are so complex, what is the result of the remedy procedure? Necessarily, it leads to complexity also in the remedies procedure if the underlying procurement material regime is complex. And the fourth preliminary remark, Karina, coming back to you. Yeah, 2011. Yes, I remember. I can promise you, I'm sitting in the council working group and I'm trying to shoot down a governance provision like in 2011. We've been not convinced at that time that is the right way forward, and I will certainly try to shoot it down this time again. Okay, you've seen the table, you've seen the interesting things that the number of cases are very divergent. Karina already pointed out the length of the thing, but the interesting thing is, what if you look at the tables and the figures coming from the national reports, and the latest figures are from 2023. Why can there be so big differences in the number of cases and the length of procedure? There is no correlation between, for example, the size of the country and the number of cases. There is no obvious correlation between the institutional setup, administrative courts or administrative bodies, and courts versus the length of the procedure. And there is no obvious correlation between the number of cases and the length of procedures. I just give you some figures. Greece, above 3,000 cases per year, 56 days. That's not that long. On the other hand, if you have Luxembourg, 6 cases, average length, 500 days. So why? Why is there such a big difference? And this leads back to effectiveness. Huh? The thing is, you cannot, let's say, dissolve or take away the remedies from the national institutional system. It is heavily incorporated and it relies on the procedural aspects of the general administrative law and the institutional constitutional setup of the member states. My system, my personal view is the system works. In some cases good, in some cases less good. This depends heavily on the national situation. One size does not fit all. That's the certain thing in this case. The thing is, you have to analyze the specific situation and the difference between the national system and the number of cases and the length of procedures are, from my point of view, really related to the procedural setup and the institutional setup of the specific situations. The remedy system is a highly sensitive issue. Yeah, my conclusion is, if it ain't broke, don't fix it. If you try to fix something which is working more or less okay, you end up in a nightmare. I'm a judge as well. I'm a lay judge on procurement. I know what I'm talking about. I'm on the other side as well. I'm advising, I'm doing procurement procedures. And I know if this system is imbalanced, you can block procedures, or you can end up in the court and you have a nightmare there where you cannot award contracts at all because you can prolong procedures for whatever time you want to do. You know, you can involve experts for saying, okay, has the contract documents, the technical specifications, are they legally justified? Are they objective? Are they proportionate? And then you have a quarrel between experts saying, oh yeah, this is proportional, this is not proportional. This gets you neither on the contract authority side nor on the company side to anywhere, because the contract authorities want to handle the contract and the companies don't want to get involved in the court for as long as possible because they have the resources, they have the planning to do, and they just can't wait for the contracts or the decision on the contracts forever. So don't rock the boat if there is no obvious problem. However, having said that, there are some issues where you can have a look at that, where we can improve things. And I think you have to differentiate between fundamental change to the system and adaptations to the system to make it work better. There are some things which we need to consider. First of all, ECJ jurisprudence has been stressed already. Francois referred to the Strabag case, which I think there is something there. Yeah, just a short story. I knew the Advocate General at that time. She was a former colleague of mine. And when I asked her about the Strabag case, I said, why did you decide in that way? And she proposed it as objective breach of procurement law may lead to damages. And I said, objective breach? Why? Normally it's the other way around. You have a subjective problem and then you have damages. And in Austria, for example, the case is where it's sufficient to have damages only due to objective reasons are extremely limited. Nuclear power plant legislation and so on. And then he said, oh yeah, you're right. We forgot about that. So I'm a little bit hesitant about the ECJ jurisprudence. Okay, but you know, it's the final court. They're always right. Yeah, they have institutionally are they right, like the judges. Huh? I'm married to a judge. It's not easy. However, there are some procedural aspects which might create a barrier to the access or to the efficiency of the procedures. For example, fees. Let's talk about fees. If you raise the fees, yeah, there is certainly a barrier to the access to the market. SMEs will not be able to pay excessive fees. If you look at the jurisprudence, yeah, there's one case, no, there's the two cases, it's the Orizzonte Salute case, and you have the case now, the EPI case, the Austrian case, where the court set a very, very high threshold. 2% of the contract value is not dissuasive. However, if you break it down and procedurally, you might do that. 2% of a 50 million contract might lead to, let's say, 60,000 euros, and which is still proportionate according to the court. But what about dealing with the lots in such contracts? If you ask for a lot and you want to go to a remedy procedure, but you have to pay 60,000 euros for a lot, not the whole contract, this might create a problem. The lawyers, they are a problem. Their institutional incentive is to prolong the procedure. Yeah? The involvement of lawyers, obligatory involvement of lawyers, might create a problem for both sides of the contract. So this is a simple procedural rules, but you might consider, and you should consider the consequences. What is the procedural rule about the obligation to exchange written observations several times? The involvement of experts, obligatory involvement of experts. These might create problems with the effectiveness, the length of the procedure. Possibility for repeated injunctions. If you want to stop a case, you can stop the case right in its track for as long as you want. Huh? What can we do about that? One of the things we've heard about it is the system right now relies on private enforcement. Is this the right way forward? I would suggest having a mixed system, private enforcement as well as public enforcement, state attorney. Yeah. One of the reasons is simply you do not bite the hand which feeds you. No, I see it in my personal experience on every single day. If you have a huge country authority, a CPB, which is dominating the market, and where the companies know if they are cut off from this market, they're going to be broke. What do you expect, and how do you expect them to behave? Will they challenge the procedures? They will be very hesitant. I know for a big ICT company, a huge international company who did not challenge an obviously illegal procedure of our CPB because they said, no, we're not going to do that. We're going to run for the next time. Is this the right way forward? I'm hesitant. We have an example. Lithuania has such a state, public procurement state authority attorney. However, the possibility has not been used. Between 2018 and 2023, no ex officio cases has been launched. So we should look into the issue. Why has this been the case? Was there public influence? Was there a problem with resources, like Bojana pointed out, that they simply have two people and they're drowned in complaints and they cannot follow up with their complaints or do not have the resources to investigate? I don't know. The damages. I'm agreeing with Francois. This is an issue, an open issue. Inkstill case, I intervened. I was not very happy about the outcome. Definitely not. We do not know this loss of opportunity. How can you calculate that? 1 out of 4. Yeah, what about the case if the fourth offer is above budget? I can cancel the procedure. Why shall I pay them in damages? And 4 people, 3 times out of 4 you have to pay and you are not getting the contract. This is public money well spent. This is a subsidy scheme, but not something we should aim for. The fees, we definitely should look at some touches, some touches about the fees that we should keep them, let's say, in a reasonable range. Landing zones possible for maximum length of procedures. That's definitely for sure, because if I know that I'm caught up in the court for 1 year, I will not go to the court because it makes no sense at all. So this is something where we should really look at that. And flexibility for years. Corinna pointed out they're used 23rd of December. You're right. I've seen, such a length of VIATs and, oh, Jesus Christ. And I don't have to look, I don't want to look at it. I want to go back to my family and want to celebrate Christmas. I don't want to check the VIATs. Even though I know 90% may be fake VIATs because they're just covering up an illegal direct award. But there should be something we should do about that. The main challenge I see, and the whole thing about the discussion of the remedies, because it's such a sensitive issue, that the Commission would need to overcome the reluctance of member states that their national judicial systems will be limited. The national system, which is there's a procedural autonomy, which the ECJ repeatedly stresses, would need to be limited in a certain way. And I think this will be the real challenge when we start talking about the remedies. And the interplay between the material rules and the revision framework I already touched about. And there's the question, okay, if the material rules, which we will see next year, if they switch over to a regulation and you have a directive covering the remedies, how is the interplay with that? Interesting thing. So I hope I was disruptive enough for Marco. and thank you for your attention.
Yeah, thank you so much to our panelists for this really fruitful discussion, fruitful opening of the panel. And I believe that we have a lot to reflect on the panel discussion. So I will not, since we are a bit behind our schedule, I will not do anything but start with the questions for our panelists and to maybe build up on the last intervention. Mr. Fruman spoke about the tension between the procedural autonomy of member states and the principle of effectiveness. And Francois, you mentioned the ink steel case. In this light, would you say that the ink steel case is in line with the principle of procedural autonomy of the member states or not?
That's a big question. Thank you. I would say, first of all, it's quite striking to see how much the question of the procedural autonomy has been dealt with by the Advocate General at length in his conclusions, not in the case. The case does not mention explicitly procedural autonomy, which is quite surprising. However, implicitly, of course, they answered basically by saying that the arguments put forward was to say the directive that I quoted is written in broad terms. That is to say, it gives like some discretion to the court to decide on whether it is necessary to go forward. The second argument, I think that quite makes sense, is to say maybe in that particular case, I'm getting back to this argument, in that particular case where there was no possibility of challenging the contract anymore because it was already enforced simply, then you should be entitled to award damage. So the question of procedural autonomy, although it's implicitly stated, might be linked to the fact that the scope of the case might be, I'm saying might be limited in cases where there are no other option. They say in the case is the remedy of last resort. And therefore, you can think that in that case, of course, if you have no other opportunities, then it's a way to make a balance with the procedural, the autonomy procedural autonomy principle. And then I'd like just to quote Steentrömer, who actually in the 2011 book I mentioned was just recalling what we know. This autonomy is clearly subject to a number of limitations, namely the principle of equivalence and effectiveness, which is overlooked by many as it appears to be a common misunderstanding to consider that the question of damages for breach of the EU public procurement is exclusively a question of national regulation. I'm sure Michael wouldn't agree on this, but one final point on that is that once the European Court of Justice set foot on this topic, I think that gives reasons to at least deal with a reform of the review directive to give more legal certainty. It's a bit like, is everything has to be regulated by the case? I don't think personally. Just take the example of the concession directives. At some point, the Commission couldn't have the member state agreed on whether we should have a concession directive. Then the case law imposed some kind of principle of transparency. And once it was set, it was in the interest of the member state that we have clearer rules. So that's another reason to have maybe a review of the review directive. Thanks.
Thank you. This constant call for clearer rules is something that is always part of the revision of any kind of a legal act, definitely the directives. And I have to say that this foundings of the ECJ in the ink steel case are kind of exotic to us in Croatia. But when we think about exotics institutes, I have to mention the Institute of Civil Supervisor in Serbian legislation. And Bojana, maybe you answered already part of the question, but what do you think about the institute? What actually went wrong in the application?
Thank you for the question. Yes, it is indeed exotic now, to come to think of it. I think initially it was introduced because it seemed exotic and it seemed, well, I don't think we will know the real reasons because the real assessment of the necessity of such an institute has not been conducted, or at least is not made public. But it leaves a good impression, I would say, to have a representative of the civil society as part of the oversight mechanism. And just to reflect on what Michael mentioned regarding this, considering whether we should rely on private or public enforcement, at that point we had both. There are options for, and still are, for ex officio instigation of the review mechanism, but private enforcement in the shape of civil supervisor was also available. Now, this institute introduced in the way it was, I think we didn't think far ahead. We didn't anticipate potential problems. The legal framework was scarce, and some important questions were not regulated in the public procurement law nor the rule book that was supposed to provide rules in more detail on the implementation of this institute. And I think, well, one of the main problems when it comes to the legal framework was, yes, it was incomplete. And also, the readiness of civil society representatives to be involved was also not at a very high level due to the atmosphere in which they functioned, due to the a lack of clear rules on all important aspects, the shortage of time to provide or to produce their report. Frequently, they were involved at a later phase than they were supposed to, so they didn't have access to all information. They weren't entitled to any remuneration, not even the possibility to have their costs covered, and sometimes they had to actually travel throughout Serbia in order to have access to procurement procedures. And there was a complete disregard for their presence at times. There was no cooperation. I wouldn't say in all cases, there were successful cases, but at times we witnessed serious, like a ping pong between the review body and the administrative court because they were able to unearth cases of serious corruption in some public procurement projects. I think perhaps it was too ambitious at the time, and maybe we could have focused on their involvement at the local level initially. But yes, this is just to name a few problems, and it was removed from the public procurement framework the same way it was introduced, a bit overnight.
Well, thank you, Bojana. And this topic brings me back to Mr. Fruman. Actually, in Croatia, we do have, you were mentioning the possibility to introduce the Institute of Public Procurement State Attorney. In Croatia, we don't have like a public procurement state attorney, but we have a provision in the law saying that the state attorney's office can submit an appeal. And this basically never happened. It happens once. Marco reminded me, and the girls reminded me, it happened once, but they didn't follow the deadline, so they didn't follow the deadline, so it was dismissed. But my question goes to you. You mentioned this special institute. What kind of specific competences would you envision for this kind of institute? And would it be something similar to civil supervisor in Serbia, or to some other story from the abroad, or something else?
First of all, I don't know the competence of the civil supervisor in Serbia. So my thinking was, if you have this kind of state attorney on procurement, I just call it that way, I think the scope of the competences should mirror the scope of the standing for private enforcement. I think it's not a good idea, just for example, to limit the competence to bring action for annulment to the contract documents, neither to exclusion decisions by the contract authority, because think about the abuse of Article 72, where you have an amendment of the contract. I think this type of institution should also have the competence to launch ex officio a procedure reviewing the legality of the decision to change a contract. So this should be done in parallel. I think one of the things is, or that there are some institutional cornerstones which we need to look about when we decide to do that. First of all, is independence. It must be an absolutely independent institution. And from a practical point of view, the resources. If you just set up this institution without enough resources or the competency, for example, to log into procurement platforms, if you're talking about electronic procurement, they should have access to those platforms, like, for example, the competition authority. So this should be, let's say, an institution which is covering the full cycle of the remedies.
Yeah, thank you so much. When we are talking about unlawful contract modification, Professor Rijswijk-Hammer, there was a point in your presentation when you kind of challenged that the direct award was one of the most serious breaches of public procurement process. But you mentioned also of public procurement rules. But you mentioned also that one of the types of the direct award is also unlawful contract modification. How often do you see appeals against unlawful contract modification in Denmark? And if the number is a bit lower, I would assume it is, maybe what are the basic reasons for this kind of situation?
Thank you. Can I just comment first on your thoughts, Michael? It sounds like you do like the oversight body, and maybe you shouldn't shoot everything down in the governance when it comes to the council, because that sounds exactly like what the commission wants. Some authority that sort of like checks and looks at contracts and see if there's something wrong, you know? So, it was much broader, I know. But just saying that maybe there is some parts in there that might go through the council as well when we see it. The last time it was only the provision on you have to keep your contracts, and I was like, who doesn't keep your contract? I assume you do some contract management during the contract period, so that one's stuck. But maybe a little bit more next time. Well, contract modification is a tricky one because there's a big wish to change contracts in so many aspects, and recently all the security issues are also something that is very high on the agenda. We don't see a lot of cases at the Danish Complaints Board. I don't have precise numbers on this, but we do see them once in a while, and I would say that those cases we see is also where there has been some publicity around it, or that they are sort of like major modifications, and we do see that such can be declared ineffective, and we both have examples of where you would see the whole contract that's thus being declared ineffective, and where you see the modification only being declared ineffective. So that also varies a bit. But I think it all comes down to transparency, and also like who wants to complain in such a case. So maybe going back to the oversight body somehow, that if you bid for some contract, you didn't win it, you're already moving on to the next contract. You're not interested in walking around seeing if someone is not following the rules in a big project. So it's only if there is something to gain for you with the private enforcement of actually complaining. And I think that's the main reason why we don't see it. There's nothing to gain from it from private parties. Maybe they don't even know it's there. And if we should have more cases, it should be the famous oversight or attorney. We have the Danish Competition Authority in Denmark. They have competence to bring complaints. They have done that 5 times. No cases on contract modification, but other issues. So we don't see it that much.
Thank you. So maybe there is a place for public enforcement in this part, maybe as some sort of general prevention, I would say. And maybe we talk about the contract modification, and we would agree all that the controlling mechanisms are the strongest in the tendering phase, but in the preparation stage and in the execution stage, they are not so strong if they're even existing. And I want to maybe ask Mr. Dorovic, what about the planning phase and the controlling in the planning phase? How do you see this part?
Yes, thank you for that question. Listening to the other panelists, something popped to mind, public interest. And I am an administrative lawyer, first and foremost. So for me, public interest is the highest value. And doing this topic, I'm considering how we can review the review system in order to incorporate the observance of public interests at a higher level. And I think looking into the procurement phase or extending the scope of review to the not procurement planning phase, which is what I meant to say, I think there's room for discussion whether it makes sense to do that. And thinking of something Michael said during his presentation, that there needs to be, mirroring or interplay between the substantive and these procedural rules. I thought of a paper that Albert Sanchez-Graz wrote, where he advocates expanding the scope of the definition of procurement in the substantive directives in order to make room for the planning phase as well. Because I think we need to look at the procurement cycle in its entirety, be it through the revision of the substantive directives or the remedies directives as well. Because I think in extreme cases, such as the ones that I mentioned, this threat of activating review mechanisms is simply not enough to push contracting authorities to act according to the public procurement rules. And in the cases that I mentioned, the biggest problems arise particularly in this phase, that I think is still in the shadows of the procurement directives.
Yeah, thank you. Mr. Bluman, you would want to add something, please, please.
Sorry, I need to do something because Shasho and me just came back from Brussels last week. We had a 2-day meeting, EXPP and EXAP. And the commission, after the evaluation report, was looking into some issues which they didn't specifically touched upon in the evaluation, looking for blind spots. And one of the issues they touched upon was, okay, shall we cover the planning phase as well? And the reaction in the room was like, oh, Jesus Christ. Because if you're touching upon the planning phase, where does the planning take place? It's within a contract authority. Nothing gets out. Yeah, that's the reason, because I have to look. First of all, I define my needs. I have to look, okay, do I have the budget, and so on. Then I'm going out, maybe I'm going out to the market, having a market consultation, but it depends on the situation. If I'm looking for bulk goods, I'm not going out because there's nothing innovation to be gained there. But if I'm going for a huge infrastructure project or an innovation, yeah, then I will check the market. Is there something out there which meets my need? Shall I choose the innovation partnership? Shall I go for the negotiation procedure? Whatever. The point I want to make is, and we've been talking about this in the ECJ a month ago at the Strominato case. It's about the diligent working of the contracting authority. The problem is there's such a big variety of the contracting authorities out there. The competences are varying to a large degree. The resources are varying to a large degree. And all those factors are influencing the quality of the planning. Theoretically, I'm with you. This is the crucial phase where a lot of decisions are taken which have a huge impact on the procurement procedure. Totally with you. The problem is the professionalization. And you cannot force the professionalization in the planning phase through procurement rules. Simply, it's as simply as that. And if the Commission starts regulating in the planning phase, we're going to run out in problems, because then the Commission will tell you, oh, you have to do a market analysis. Oh, what the heck? What kind of market analysis I'm supposed to do? Proportionality principle for 20 million, for 5 million, for 4 million, for 200,000. It's always above the threshold. But what kind of resources shall I pull in the market analysis? And this leads to a lot of questions. And if you can challenge this already in this phase, I will promise you, we're going to be stuck in procurement. We will not be able to hand out contract, because if you open up the challenges to this phase already and not even starting the procedure, God may have mercy with us.
If I may just add something, what if we think about the middle ground? I agree that it raises a lot of questions that we need to answer before implementing something that sounds nice at the theoretical level. But I think we can all agree that the planning phase is crucial. So what if we consider opening up the possibility of challenging, for example, the incompliance with sustainability criteria? And I go back to my presentation and the problems therein that take place in the planning phase. Perhaps that is something to consider, because what you started talking about, the contracting authority will conduct a market analysis, all of that. And the whole time listening to you, I kept thinking, but what if it doesn't do all of that? And I think contracting authorities frequently fail to do that. What if the problem of the failure to introduce or to properly implement sustainability criteria goes back to the planning phase? What if?
What about e-resilience?
Oh,
the problem is you have such a variety of policy objectives right now. We're trying to square the circle. We're trying to procure something which is innovative, social, green, EU resilient, and costs nothing. Please show me anybody who can do that. I'm really provocative in this regard. But the thing is, right now, we do not have a priority of policy objectives we want to achieve. Is procurement about policy objectives, strategic objectives, or is this an economic function of the state where we want to buy something because we are obliged to deliver public services? I think this is the first function procurement is about, that we're delivering something for the state, for the people out there. And there are to be some considerations. But I'm hearing always, oh, there's such a lot of money and we shall use the money, yeah, to put pressure on the market. Yeah, we can do that. But if I'm looking, for example, at the implementing regulation in NCEA, and the Commission says in the recitals that, for example, I think the wind turbines, offshore and onshore, the scale of the market, of the public procurement market, is 3% of the whole market. Are we supposing that we can move the market with a demand which is the size is only 3% of the whole market? This is not the right tool to do that. So we need to look at, to be sensible about it and need to differentiate. And that's my point. And if we're saying, okay, let's open up environment, the next question is, why only environment? The policy question will inevitably rise and say, okay, we need to do everything at the same time. And this is what I'm afraid of. Thank you.
So you wanted to comment on this?
Yeah, just to make the link between all our arguments, but for once, I would agree with Michael on the fact that we need to be cautious about legal standing And I have this example in mind where I asked one of my postdocs to do statistics about contract modifications notices at EU level, where we discovered that France has made, for the last 10 years, 22 times less contract modification notice, has produced 22 times less than Germany. Does it mean that they made 22 times less contract modifications? Not at all. So we interviewed our partners from the public side, public sector side, and they say, well, you know what? We don't respect the rule, right? We don't respect the rule of publishing contract modification when it's compulsory, simply because in France we are too generous in terms of legal standing for third parties. So this kind of side effect of the good will that we should publish, then we don't apply because the legal standing rules are different from one member state to another. So that's one point. Another point on public enforcement, we've been considering public enforcement through like a public prosecutors, which, by the way, ends up before courts. We can think about public enforcement in different ways. I know, for example, the system of Quebec in Canada, which they actually monitor the way for example, contract notices are published. So they've got systems to monitor, to try to see whether there can be problem in terms of reduction of competition, for example. And then they could go on site to check how the procedure was conducted. So it's an alternative, I would say, public enforcement system. I have a few words to say about calculation of damage, but maybe later on.
I would ask you now to say a few words about calculation of damages because we are running out of time. So we have to use Francois because he's coming from France, from a country of a legal system with a long-standing actually tradition of recognizing loss of opportunity as a ground for damage. So how do we calculate it?
Yeah. So it's not strictly loss of opportunity. It's quite similar, but it's not strictly in the sense that, as I said, it was like only if you have a high probability likeliness of getting the contract that you could get damages. So two things, by the way. What are we talking about? Loss of profits and bid costs. Quite interestingly, in France, we said it's either one or the other. That is to say, if you cannot claim that you had a fair chance to get the contract, you can only claim bid costs. Whereas in the case I was mentioning, the General Court, they say you could claim both. In France, the French Conseil d'État would say your bid costs are necessarily included in the profits, which is, by the way, the case. I interviewed one of my partners who explained to me they need to win in public works. They need to win one bid out of 8 in order to cover the bid of the 7 others, which means that actually it's of course included in the margin of profit. So now, if you have one or the other, in terms of bid cost, it's just a question of how many days were necessary to prepare. There can be arguments. In the Vakakis case I was mentioning, there were arguments about how many days was necessary. In France, we had a case where for the construction of the Stade de France, the biggest stadium in France, it's a concession contract. The award was declared illegal for breach of equality in 1994. A law secured the contract, an act of parliament secured the contract, so they couldn't only claim damages, they couldn't claim loss of profits, so they claim bid cost, and they ended up with 500,000 euros, which is huge, but it's very exceptional. It was like concession contract of 30 years, construction, etc. Now regarding the question of the loss of profits, in the Vakakis case and in the French case, what we do is that the court would assess the usual similar contracts and the margin of profit in similar contracts. So we know that in public work contracts, it's 3 to 5%. In supply contract, it would be like 15 to 20%, depending on the sectors. So that's the usual rule. Now, to get back to the point that what is the risk? Of course, there's a concern, including the French member of the Conseil d'État, how to implement the ICSIL case. There are concerns about public money protection. actually you can think about ways to limit the impact on public money. First, the causal link. Causal link, for example, of course, as I say, direct award, you're not sure about there would be a causal link because it's not high probability. You can think about causal link in terms of, for example, we've got one candidate left. You know that as a contracting authority, you can decide to finish the award procedure for lack of competition. That means that it's not necessarily 100% of damages. In that case, you could argue that there was a likeliness that the contracting authority would end the award procedure because of lack of competition. And therefore, it's really up to the judge to decide whether it would be like 50%. So you could limit the risk. And then another issue I think is overlooked in France. They said, the French Conseil d'État said, we don't have to look at it. I think the best way to limit the risk of paying money, as Michael was pointing out, is to say, as a claimant, you should prove that you would be able to perform the contract at the same time you perform other contract, because of course the company got other contract. So were you able to do both if you had won the contract? Conseil d'État said it's too complicated. So I'm arguing to them, well, it's the claimant's duty to prove he could have done both. And if he cannot prove, then that's fine. No loss of profits. So there are some tips to limit the risk for public money.
Thank you so much. Since we are running out of time, I will just leave one question finally for Marco, from Marco for you.
I apologize. I really apologize, but thank you all for your beautiful presentations. But unfortunately, somebody, I think it was Michael, mentioned Horizonte Salute, which is one of my trigger words. So a question for all of you. Has the time come to abolish appeal fees across the member states in the future revision of the Remedies Directive?
So what you're asking is if there should not be any fees? That's a good question. But first of all, I don't think if you're looking at it from a Danish perspective, our fees are not very high. So I don't think that that really has anything to do with the number of complaints that we get. It might be higher in some member states, and that could be a reason for not having that much cross-border complaints. If you are unsure what that actually means, or if you're calculating based on different measures. We could abolish fees. I don't think I have anything sort of like, I don't think it matters from a Danish perspective on that one. We increased the fee dramatically. What is that? Maybe 15 years ago, something like that. And we saw a reduction in the number of complaints. But today, I would say that the costs for complaining, the money that they pay the most bidders would be to the lawyers, actually. So I think if you just reduce the fee, they will probably just charge a little bit more, the lawyers. So they end up being the same amount of money in that regard. But yeah, good questions. Yeah.
A quick answer. I know that it's really an issue in Croatia. In France, we don't have any appeal fees. But my point is that it's very political, very sensitive. And in terms of procedural autonomy principle, that might be a bit challenging.
Well, I go back to civil representatives of the civil society. If they were to be given standing in public procurement procedures, I think in that case, we should definitely revisit complaint and appeal fees. In other cases, I have to say I haven't given this topic too much thought, but to the best of my knowledge, it's not that much of an issue in Serbia.
It certainly is an issue in Austria. I would certainly not abolish the fees, at least in Austria. I think it's depending also on this kind of national attitude. There, in some member states, I see that economic operators are much more prepared to go to the court and fight than in others. France, for example. So I would keep the fees just to stop frivolous challenges and abuse of the remedy system. Because if there are no fees, what keeps economic operators for saying, okay, I know I have no chance, but since it's cost me nothing, I'm gonna challenge the procedure, gonna stop you, gonna stop my competitor, unless, and that's the deal of the thing in the backyard, saying, oh, I'm gonna be a subcontractor for you, and then I'm gonna pull back my action, and then everything's fine. The fees, certain fees, stop it. My problem is excessive fees, yeah, but I would not get rid of them altogether.
Well, thank you all so much. We could go on with the discussion forever, I guess, but we all deserve a little restricted coffee break for just 15 minutes, unfortunately, but enjoy. Thank you once again.
Yeah, excellent.
Hoćeš sa profesorom?
No.
Imali smo ti panike, link nije radio, pa smo stavljali novi, pa su nama stavili ljudi, pa smo izlazili van kao.
Znam. Znali smo da će se
To, nego sad ti sa zvuka. Dobro s tim prolazna prolazna, ali dobro, sve ok. Sve ok.
Oh, nice to meet you. Nice to meet you. Did you contact me via LinkedIn?
Yes.
Yeah, of course. So good make it.
This,
Uh-huh.
we are starting. Yes. So, after second, I have to.
Yeah.
Just to
Okay.
our.
Absolutely. Yes, ma'am.
Imena je...
Rekla je
Ili još treba nešto vodu? Samo nek ona sad uzme ovu plastiku i taman napravi za sljedeći ovaj.
Like the house with the prayer and open act.
Da, da. Nema njelo, a sam ne može. Esnice tu, da će staviti.
It's fine. It's okay. I have to run the vet. First one. Propone convencimiento de ministro, mas não se
Yeah, the light is coming out of the place. Hey, perfect. How long does it take you? Yeah, with the AI, yes. Each control. All question.
Da čeka voda i sve. Bod, sve se da će. Daju se bilo sve. A, počneš.
Your turn. I think we should call you after the echo incident. Marco.
I love to hear my name being spoken out loud, so I have no problem with it. There was an issue on a live stream. So So, hopefully now you'll be hearing me just once from one audio track. And reciprocity or protectionism, public procurement and international trade. Another hot topic in public procurement in recent months, in the recent year. And I have to admit, I have mixed feelings about this panel. Yeah, we're going to get to that. Firstly, because we should have had 4 panelists today in this panel. Unfortunately, we have only 3, and this is a sombering experience. And the second one is something Piotr was prematurely laughing about, because I really hate the calling judgment, as many of you know, and I tend to think a lot about and write a lot about things I hate, remedies, calling judgment, and so on. So it's a kind of a love-hate relationship, and I have obvious problems character-wise. So it's sometimes hard to talk about these issues. But I think we have a brilliant panel nonetheless, a panel that encompasses really important and different perspectives on this topic. We have a perspective from the US, perspective from one of the member states of the EU that has unique views on international procurement and third country economic operators, and a perspective from Europe but outside the EU, perspective from Switzerland. So it's my great pleasure to introduce Professor Christopher Eukins, who teaches in the Government Procurement Law program at George Washington University Law School, which is the leading program of its kind in the United States. He teaches contract formations and performance issues in public procurement, bid protests and claims litigation, state and local procurement, anti-corruption issues, foreign contracting, and so on. Piotr Bogdanovich is a professor at the University of Warsaw Faculty of Law and Administration, where he lectures on EU law, including EU public procurement law. He is the author of several books, the most famous one probably on contract modifications in EU procurement law, and has published articles in leading journals, including the Common Market Law Review, Public Procurement Law Review, etc. And Desiree Klingler, who is an assistant professor of public law, University of St. Gallen, Switzerland. She is conducting research at the intersection of law and economics with a focus on public economic law, climate law, and international trade law. So I would like to give the floor to Professor Eukins, who will be talking about reciprocity or protectionism from an international perspective. Thank you.
Thank you very much, Marco. So just a quick note on Chris Bovis. So what Chris and what other older professors had taught me, which is really important because there's so many young academics in this room, is Chris was always dedicated to the discipline. Whenever I had a lot of back and forth with Chris on the Lexion publication, the European Public-Private Partnership Public Procurement Law Review, whenever we had a proposal, like for example, the proposal that's on the table right now is, should there be a blog that's associated with the journal in order to move into the open source some of the scholarship that's going on inside the journal? And Chris said, that's a fantastic idea. And so he was constantly responding favorably to ideas and people that advance the discipline. And that's something that's his legacy. We are here to advance the discipline, and I'm very grateful for that. So what I want to talk to you guys about today is some of the trade issues from the U.S. perspective. And since many of you are young academics or young lawyers to be, I want to give you a little bit of background. You're going to be working in an American environment where you're dealing with Americans. Give you a little bit of background on your counterpart culture in the United States. Now, I got to tell you that the basic procurement structure is exactly the same all over the world. Chris Vida, who is the last UK judge on the Court of Justice for the European Union, came and gave a presentation as he was leaving the Court of Justice. He's not at Monkton Chambers now in London, but Chris came in and gave a presentation, and he said he went through all the most famous cases of the Court of Justice for the European Union in procurement. And he was proudly reciting all the important elements of procurement law that they developed. One of my students who ended up being at the University of Turin, she got her PhD from the University of Turin, she thought that there was going to be a quiz. So she was writing down everything Chris said about Court of Justice, and she was giving the analogs to American law, some of which was 150 years old. And at the end, she said, "Look, Professor, I got it all right." And I said, "No." And when the judge stopped talking, I said, "Judge, great presentation, but everything that you've said about Court of Justice precedent, we actually have here in the United States, and we have had it sometimes for more than 100 years." And he was completely shocked, which generates real questions about whether or not we should have more dialogue like this, so the Court of Justice doesn't kind of wander in the wilderness when other systems have already thought about this. That's a big part of why we do so much comparative work. So I want to focus on with you, because it's so top of mind right now, the Trump tariffs, and give you a little background on the Trump tariffs. And this is Trump on Liberation Day when he announced all these tariffs. And I like Francois, I want to give away the show before we started. So the question is, what were the Trump tariffs for? The Trump tariffs were ostensibly to address a chronic trade deficit in the United States. But it's not a trade deficit across the board. It is a trade deficit with regards to goods, not services. In fact, with regards to services, the United States has a substantial surplus, and many, while economists would be maybe split on whether or not on a macroeconomic basis a trade deficit matters, there might be some disagreement. They're uniformly agreed that tariffs are about the stupidest way in the world to address a trade deficit. So trade deficit, first question. Second question is industrial policy, that we want to rebuild the American industrial base. And for those of you who, like Piotr, has traveled across the United States, as you travel across the United States, it is an industrial wasteland in many places because a lot of the industrial core has been pulled away since World War II. So is it to build up the industrial base? What I'm about to show you from the U.S. procurement system shows that that's not true. The Trump policy, the Trump administration created and enforced an exception for U.S. defense procurement, which means that U.S. defense procurement and the U.S. defense industrial base is not necessarily being helped by the tariffs because there's a window, there's an exception to the tariffs for defense items. So the industrial policy argument for tariffs goes out the window. The third possible argument for having is to generate revenues, that the tariffs generate revenues. But this last weekend, Trump announced that every American who's not rich, he didn't say what rich meant, but if you're not rich, every American is supposed to get $2,000 back from the tariffs. They're just going to disgorge. That's his idea, is just to disgorge it. And which means that the revenue argument goes out the window for tariffs. So what's left for tariffs? Why do we have tariffs? Answer is probably Trump's ego. And while this argument couldn't be put to the Supreme Court last week, which is the tariffs are stupid because they're really about Trump being able to exercise his ego, everybody knows about it in the background. It sort of lurks in the background. Now, what's also lurking in the background here is, just so you know, for those of you who are dealing with Americans, dealing with the American lawyers, dealing with the American establishment, lurking just off camera here is Peter Navarro, who is his trade advisor, Peter Navarro. Does everybody know how Peter Navarro spent his last summer? Not this year, but the year before. Does everybody know? He was in a federal prison. Okay, he was in a federal prison for contempt of Congress, which in our democracy is a big deal. When Congress asks you a question, you answer the question, and you don't say, no, go to hell and go to jail, okay? But Peter Navarro did. In the American establishment, if you're criminally convicted, you're done. That's it. Maybe you change your name, but you definitely move away, and you move away. You're no longer publicly involved with anything. Unless, of course, you're Peter Navarro in the Trump administration. So you have a convicted criminal just off camera here. And it can give you an idea of how skewed things are in America right now, okay? So these are the Trump tariffs. And going back to this question of ego, if you look at the map, what country has been hit most hard by the Trump tariffs? Dark there, Brazil, okay? This has nothing to do with industrial policy. It has to do with the fact that Trump is buddies with Bolsonaro. He's punishing Brazil because Brazil is punishing Bolsonaro. So this proves the thesis that the tariffs are really about Trump's personal power, because he's focusing on a country where, if anything, the United States should be opening up. Brazil historically has been very protectionist, is moving now towards opening its borders. We should be opening our borders with Brazil. We shouldn't be attacking them just because they have a dispute, a problem with a former president. So two other maps here that are very important from a procurement standpoint. This map here is the government procurement agreement. It's member nations, it's signatories, and the ones that are in yellow those are observers who are pending. And we could have a long discussion about that, but this is the GPA. In the upper right is something that most of you are not even aware of, but from an American trade perspective, very, very important. These are the nations that have reciprocal defense procurement agreements with the Defense Department. It's typically between the Ministry of Defense of, say, France and the Defense Department. They enter into a bilateral free trade agreement. These are, for those of you working in the defense world, these are incredibly important to defense companies. It is basically a free trade zone, bilateral free trade zone for American weapons companies selling weapons abroad, and they do it through reciprocal defense procurement agreements, which guarantee open borders with regards to defense supplies, services, and research and development. So they're incredibly important trade agreements in the defense world, with the United States sort of the hub of a wheel with many spokes, primarily to NATO allies, but also to some non-NATO allies. And an open question would be, as Europe develops its own defense procurement world, do we go from a hub and spoke to a broader set of multilateral or plurilateral agreements like we have with the GPA? So this is the actual language from these various trade agreements. And I'm about to tell you about an exemption from tariffs for defense items. Okay, that's interesting, Chris. Well, does that exemption come from these trade agreements? The answer is surprisingly no. The answer is no. If you look at the GPA, the GPA is in the middle bullet there. The GPA specifically says that tariffs are okay. So even though the United States and the European Union are both members of the GPA, they can impose tariffs on each other. They're not covered by the GPA. The reciprocal defense procurement agreements, I've taken one. Remember, these are multilateral defense procurement agreements. So many, many different countries have entered into them with the United States. I just use the UK because the UK is a good and easy example. If you look at the language up there, it says that in the last says, each party shall use their best endeavors to waive their charges for customs and duties for procurement, to which this MOU, they call a memorandum of understanding, applies. So I look at this language and I said to a woman I work with, who's a very good trade lawyer, I said, does this mean that on the reciprocal defense procurement agreements, there's a tariff exemption under the reciprocal defense? She laughed. She said, no, that's stupid, Chris. You're so naive. No, this is a best endeavors language. This does not mean that we're going to give a tariff exemption. We're going to try, but we might fail. In trade terms, this is a lie. It's basically a lie that this is going to be a tariff exemption. So it means that the reciprocal defense procurement agreements don't create the tariff exemption or other. And then down here, I just took another free trade agreement, the one between the United States and Australia, and again illustrate that the free trade agreements are not generating the tariff exemptions. So what happens in practical effect? Now, I'm giving you this one because for the teachers in the room, this is a good illustration of how to use AI to terrify your students, okay? This illustration here on the left-hand side was created using AI. It's supposed to be the code of federal regulations. The AI forgot to put the of in. So I use illustrations like this all the time with my students to say, don't rely on AI, kids. Don't do that, okay? I let them use AI for general research, but I say it makes a lot of mistakes. And if you say it makes a lot of mistakes, they say, oh, this is another old professor talking. And you show them text. They say, oh, yeah, it's just text. But if you show them a picture, you've terrified them. That's the goal. Okay, the thing here is that this language here on the right-hand side means that tariffs, generally speaking, are supposed to be applied in U.S. procurement as a general matter. So the general rule in U.S. procurement is that tariffs are applied. But the Defense Federal Acquisition Regulation Supplement, or DFARS, the DFARS create an exemption. So an agency created an exemption on its own from tariffs. And by the way, this is sort of more of a tour of America. Look over here on the left-hand side. What is the agency called? The agency is called the Department of War. Well, that's not its legal name. The legal name is the Department of Defense, and this is a very different thing. The Trump administration is calling the Department of War. So now you will be able to tell Americans, is the American you're talking to left of center or right of center? Because the left of center Americans will say the Department of Defense. The right of center will say the Department of War. It's a way of sort of sussing out who it is that you're talking to. But look here on the right-hand side. This regulation creates an exemption. It says qualifying country supplies, which are supplies from reciprocal defense procurement nations. Eligible products, those are products from GPA nations and from other free trade nations. They're going to be presumptively exempt from tariffs. But look at the one on the bottom. That's the big clue. Other foreign supplies for which the contractor estimates the duty will exceed $300 per shipment. Well, I just showed you a map that told you presumptively everybody has a 10% tariff on this, under this insane 18th century policy, okay? This one says every time there's tariff costs over $300, this means that every single shipment from the Defense Department for more than $30,000, which is all of them, okay? The Defense Department never buys anything for less than $30,000. Every single shipment should have a tariff exemption. Very sweeping. Okay, so another part of what's going on in Washington you need to understand is that there are mandarins in place who have been there for a long time, and they trust each other, they signal each other, and they are going to outlast the Trump administration if they possibly can. John Tenaglia, who is the head of procurement policy in the Defense Department, is one of those people. It's older men and women who take their commitment to the United States and to an effective procurement system very serious. Sort of the American counterparts to Michael Fruman, okay? They take it very, very seriously. And so when they say something, they're very careful and they don't say anything that's impolitic, but you know they're not lying, which sets them apart from a lot of the Trump administration. So John Tenaglia issued a memo in August, and I looked at it just before I got on the plane here. I looked at it to make sure it's still in place. John Tenaglia, one of the longtime mandarins, he issued a memo saying, no, we're really going to exert this exemption. It really matters. We're going to do it. And so to bring the attention of all the contracting authorities within it's about $800 billion marketplace, about 550 or so, or 600 billion of that is defense. It's a huge portion of our procurement. So when John Tenaglia speaks, America listens, and it's a big deal. And he said that the defense exemption is going to apply. Look at why he said to maximize the department's budget to meet warfighter needs. That's Trump administration speak. We have to build up the warriors in order to make them successful. That's a euphemism. In American politics, that's a euphemism. You step outside the Pentagon, you never say, we have to help the warfighter. You have to say very simply, if we don't buy the best possible technology, and that might be Swedish, it might be French, it might be whatever. If we don't buy the best possible technology, more American kids will die. And that's a very serious statement, because most of us know people who have children who've died in battle. So we take it really seriously. And it's an important distinction in the European discussion. Oftentimes people say, well, we should have a European preference. It should be all European. And you say, well, in the defense realm, that means more European kids will die. How can you say that out loud? It's a really important distinction in the narratives on both sides of the Atlantic. Okay, so for the professors in the room, one of the things that I do, and the learning professors, one of the things I do every year, on the Defense Authorization Act, it contains an entire Title 8 includes all kinds of procurement reform measures. My students are overwhelmed by it, typically 100. So what old Professor Eukens does at the beginning of the semester, now every year, before the spring semester, is I write a distillation. I say, these are the 40 most important, so that the students can decide. They can decide themselves what they want to write about, which they think are the most important from my distillation. It's counterintuitive as a professor, because it's not really analytical. It's just a narrative distillation. It runs against what I should be doing as a professor, but I do it as a pedagogical tool, and actually works very well. The Defense Authorization Act is in limbo right now. It's in conference, which means that the House and Senate versions are being reconciled. And now that the shutdown is over and the Senate is back, we're going to move probably in pretty short order to get the National Defense Authorization passed. Just so you know, in the American system, there's an appropriation and there's an authorization. The joke is it's like a father and a mother. You go to the mother to ask permission, and you go to the father to ask for the money. That's the joke. The authorizers, the permission givers, are wiped out on Capitol Hill. There's only one authorizing committee, one set of authorizing committees that matter anymore. It's in defense. All the other authorizers, like any given agency, the authorizers have basically given up, and all the power has gone to the appropriators, the people who are actually appropriating money. So this is an interesting vestige of an authorization process that actually matters, and Congress doesn't want to give up this power, but the Trump administration has every incentive to destroy this because it's one more source of congressional oversight. So what everybody is watching for in Washington is, will this authorizing process be destroyed by the Trump administration? We'll see. It's possible. It's been going, they've been doing authorization bills for 60 years, but it's possible to be destroyed because it is oversight. So getting back to the nitty-gritty here, Section 874 of the Defense Authorization Act on the Senate side includes a provision explicitly calling out this exemption. And it says that that the Defense Department should honor reciprocal defense procurement agreements, and by honoring them, they should make, but we've already showed you the language. The languages don't actually create a tariff exemption. Essentially, what the Senate is saying is there should be the same exemption that already exists in Defense Department rules. So you say, well, why would they do this? Why would the Senate do this? And they also called, for example, they also called for a study of the economic impact, these tariffs. Why is the Senate throwing this spaghetti up on the wall and saying, you have to honor a tariff exemption that already exists in the regulations and already has been reinforced by that August memo? The answer may be that the Senate is trying to give John Tenaglia and the other mandarins cover to honor this defense exemption, because the Trump administration, in their statement of administration policy, they responded, so the response is from Russell Vought at the Office of Management and Budget. And it's a running joke in U.S. government. Who's really in charge of the U.S. government? The Defense Department or the Office of Management and Budget, which is part of the White House? Legally, it's supposed to be Russell Vought, who, by the way, to give you an idea of how small our world is, Russell Vought, who is the guy who runs this, who's an awful, awful person, he is a graduate of our law school. And he, as head of the Office of Management and Budget, they wrote this scathing response. Look what he said. He said, no, you shouldn't have a tariff exemption because this provision would undermine domestic capacity building efforts by allowing the Department of War to bypass the administration's tariffs, which were created to address trade imbalances and restore our nation's atrophied industrial base. Okay, if you believe that, you haven't been paying attention, okay? That's a specious argument. That's an empty argument for the tariffs, but he's banging on the table. Well, why is he banging on the table here when back here, his own Defense Department has reaffirmed the tariff exemption and they haven't changed the rule? The rule still exists. So this may be intended from the Senate to give political cover to the Defense Department, and this may be intended to create credibility behind the tariffs, the Trump tariffs, that fundamentally lack credibility. Because the Defense Department essentially has by its tariff exemption, has made nonsense of the argument that this is good industrial policy, because the defense industrial base can bypass the tariffs now. The Defense Department, with roughly $500 or $600 billion in spending, can bypass the tariffs, making complete nonsense of the Trump administration argument that this is really an effort to build up the U.S. industry. Okay. So the questions that are left for us, we've already talked about the first discourse. I just want to talk the bottom ones. It's kind of interesting to understand the separation. Most foreigners don't understand, most folks outside the United States don't understand the difference, the distinction between federal procurement and state and local procurement. State and local governments are not the same as the federal government. They're not part of a unitary system. It's not like Europe at all. And the state and local governments are stuck paying these huge tariffs. And they're very upset because state and local governments have less money to spend in the United States. So the first open question is whether or not civilian agency procurements should have the same exemption that the Defense Department has put in for itself. And a related question is, because our centralized purchasing agency, our main centralized purchasing agency, the General Services Administration, does what you guys call joint procurement. We call it cooperative purchasing. It is a federal agency that allows state and local governments and Indian tribes to buy off the framework agreements, to buy through its framework agreements. So if our civilian centralized purchasing agency at the federal level had the same exemption from tariffs, it could set up an interlocking system with state and local governments. And there are very well-established framework agreements that would make this work. They could set up an interlocking framework so state and local governments using joint procurement would also be able to bypass the Trump administration tariffs. So all this, of course, turns on what the Supreme Court does with regards to tariffs. I am less hopeful than others are. The Trump administration, because they have so much invested politically in tariffs, even if they lose the authority under the International Emergency Presidential Powers Act, they are likely to use other authority to try to impose tariffs. So this issue, this policy conundrum and how it works in the public procurement realm is likely to continue even if the Trump administration loses the pending Supreme Court case on the initial tariffs. Thanks very much.
So as Mark introduced, in Poland, we have many experiences after calling and Xingdao judgment, and I would like to share some of them with you. I assume that everyone, or nearly everyone in this room, knows the judgments, so basically I will not present any thesis, I will not recall them. Instead, I will start from something that Marco actually started as well, and then spilled the beans. So his words, his position about calling judgment, and don't be fooled about the picture that no one stands behind Marco and then his position about the calling judgment. Nonetheless, when we think about calling judgment in Poland, is quite to the contrary. And again, in order to show you, let's look at this gentleman, not that handsome as Marco, Damian Kaźmierczak. He's a board member of Polish Association of Construction Employers, and these words were said few days after the law implementing calling was adopted in Poland. And as you may see, the approach is very, very different after years of fruitless appeals, moving from an overly hospitable, even caricatural attitude to a more rational one. And Mr. Kaźmierczak is very happy about the European Union, which made so playing a significant role in this change in the mentality. I'm referring here to the landmark ruling of the Court of Justice. And then to give you a flavor how much important this topic was or still is in Poland, these are some statistics from last 3 years showing the number of awards to economic operators from third countries. The numbers were pretty much similar, so around 10 awards. The value was different, and especially last year it was really high, nearly 5 billion euros, because of one huge contract given to the consortium of Polish, Austrian, and Chinese entity building some part of a huge Polish airport. And given this in mind, one could think, so what are the possible solutions? What to do with the judgments? How to regulate the access of economic operators from third countries to local markets? And of course, we have different, although to some extent they are similar paths. At national level, the most obvious one was to leave decisions to contracting authorities, so totally in line with judgments of the Court of Justice. Then one could think about adopting some guidelines, or even go further and adopt some implementing law. The European Commission in their question and an answer non-paper suggested that it could be possible, just in order to change the law before calling and allowing full access of economic operators from third countries to their markets. And actually in Poland, we had it. So the law before calling judgment was saying that economic operator is any entity, so without any reference to the seat or being controlled by EU entities, and the reference to general principles of procurement, so non-discrimination, equal treatment, free competition, etc., was ensured for each and every entity, including economic operators from third countries. And of course, after calling and Xingdao judgments, one could argue that basically these provisions should be then interpreted in line with the judgments, so applying indirect effect of EU law. Nonetheless, one have to remember that one of the restrictions of this indirect effect principle is contra, so not to interpret these provisions contra legem. So one could argue that this would be this would be against. And then at EU level, we could also, of course, try to implement this judgment by amend current directives, but of course it takes time. We could think, and I was advocating for it, that the European Commission could have issued a communication, but a proper communication, not this non-paper, but a true communication which could explain this judgment, as the Commission did in 1980 after the famous judgment Cassis de Dijon, which really shaped free movement of goods. It took the Commission then 1.5 years, so still we could hope that this will happen, because we are just 13 months after calling judgment, but that could have been a solution. Or, but of course, this does not depend on the European Union. Maybe there is another preliminary reference, and the Court of Justice could elaborate on some issues. The problem is that in this case, again, the Grand Chamber would have to sit in order to change this. So these were potential paths, and actually in Poland we have all of them. We have it all, and starting from the judgment of the court from 23rd June this year, a really interesting case because the tender was launched before calling judgment, and the deadline for submitting bids also were before calling judgment. But decisions were made afterwards, because in the meantime, calling judgment was issued. And there were basically two competitors: a Turkish entity, a Turkish company registered in Turkey, and the Polish one. And the contracting authority, following calling judgment, decided to reject the bid from Turkish entity, which was then challenged by this Karsan entity. And in the first instance, the appeal was the appeal was accepted. So basically, the first instance body said that because the contracting authority did not say anything in the tender documentation about the access of economic operators from third countries, then it could have not rejected it bid nor excluded. But then Solaris, so Polish company, appealed from the judgment, and its complaint was accepted. Basically, the court accepted explanations from the contracting authority that nothing in law has changed. This is just the Court of Justice interpretation of existing law, and that the contracting authority at the time when it was rejecting the bid could have relied on the opinion of the advocate general. So that was the case. Then we have a number of, so this is the judgment from the court, but we have a number of judgments from the first instance body. And actually, the most interesting ones are those which relate to the participation of consortia in the proceedings. Consortia consisting of Polish entities or EU entities and entities from third countries. Like in this case, very recent judgment from August 2025, a really huge tender concerning the construction and modernization of one of railway lines. And in this case, the bid coming from the consortium of Polish entity, Polish company, then a subsidiary, a Polish subsidiary of Turkish entity, and a Turkish entity was rejected based on conclusions from mainly Qingdao judgment. And one can consider which judgment is wrong, this one or Qingdao judgment, because in my view, the court, it could be quite difficult to say to the contrary based on Qingdao judgment. But the outcome is that in such case, the outcome is detrimental to some EU entities, including Polish entities, which decide to to start in consortia with economic operators from third countries. In the meantime of those judgments, Polish Public Procurement Office decided to issue some guidelines in which it tried, and emphasis is really tried to explain both judgments. The first one was issued actually very quickly, few weeks, 2 weeks after calling judgment, and was not very useful and to some extent even misleading as what the contracting authority has to do, so whether it is sufficient that it will not say anything, and in such a case economic operators will be excluded, or it has to specify in this tender documentation, and that was the position of the contracting of the public procurement office. Then these guidelines were repeated, and quite recently the public procurement office issued a set of 25 questions and answers, which are most detailed amongst any of these guidelines, and to some extent even revise the previous position. And the date, that there's no coincidence about the date, because as you will see in a sec, in the meantime, the law implementing both judgments was issued on 9th of July, entered into force on 9th of September. And the main principle is presented at this slide. The contracting authority may specify in the procurement documents or in the tender notice that, and then look at this, because the scope is really broad. It does not only refer to economic operators, but to consortia, to entities on capacities of which contractors rely on, to subcontractors, and even to further subcontractors, right? So this is really a complex. This is really a complex regulations, and that's one thing. The second thing is that there's a number of doubts regarding the wording and then the language. And the problem actually we have, that we allow to member states to implement on this judgments, even taking this first part, contractors who conduct business activities and have the registered office or place of residence. If we use it collectively, what about entities who basically conduct business in the EU but have registered office or place of residence in a third country? Being an advocate, I would advocate that this does not relate to economic operators from third countries. And actually, there are more and more doubts, especially regarding subcontractors, because as we all know, in some cases, to some extent, there might be a requirement from the contracting authority to put the names of subcontractors, but in many situations, basically, these subcontractors are being appointed at the stage of performance of the contract. And how to control first of all, how to control the appointment of such subcontractors from third countries in practice. The second thing is that who will control that? This will not be first instances bodies, no public procurement codes, because we will be at the stage of the performance of the contract. So basically, this will be common codes. Third, what about suppliers? What about entities providing services, which in Poland are considered to be subcontractors if only these services or supplies are required for the execution of a contract and then are accepted by and reviewed by the contracting authorities. So a number of questions, apart from the main one. What about the exclusive competence of the European Union? Again, and to recall, it looks like that the European Commission, to some extent, allows for that, but this extent is quite limited, and we go much farther actually than this. And the last thing about that, really controversial, and also again quite the irony. Actually, there are two ironies. First of all, I'm talking about the access of economic operators from third countries on a special day for Poland, because we have today Independence Day, so we are very much independent. We don't want to admit entities from other countries. But the second thing is, as you probably know, Poland struggled with rule of law for many years, quite recently. And when we take seriously what the Collin judgment says and what the European Commission says about the access to remedies by economic operators from third countries, I think that we actually struggle more with the rule of law, because not admitting any remedies, or maybe not the direction, admitting in theory based on domestic provisions, which in practice means that, and I will explain it in a second, in a while, that in practice means that you do not have any remedy, may go against. Here you have the example of Polish constitution, but also European Convention on Human Rights. And why I said in practice, or we differentiated between in practice and then in theory, because in theory you still can go to the court. When you are the economic operator from third country, you can still bypass. You cannot go to the first instance body. You can go to the common court. The issue is that there are no automatic suspension, and the length of the proceedings is approximately 1.5 years to 2 years in the first instance. No one will wait for it, and to compare, first instance bodies adjudicate within a month, right, from the decision. Thank you very much.
Such a lonely photo, Piotr. You could have at least photoshopped some people around me.
So I'm the only one standing between you and the lunch, so I have a very hard position. Plus, I'm also, or Switzerland is an outsider, standing between the fronts of the United States and the European Union. As you might know, we're also currently negotiating the bilateral threes with the EU, because Switzerland is known for cherry picking. But I think these gap loopholes are being closed, or at least narrowed. So we are definitely, so to say here, have a little bit of a different or difficult perspective. Actually, just yesterday, and that's not so much about the FSR, but I think it plays into the whole protectionist narrative. I was asked by a journalist if I could comment on a tender that was awarded by the Swiss Federal Railways. It was awarded to a German company, not to a Swiss railway company. And there was an outcry, that can't be. And I said, like, well, unfortunately, the public procurement rules apply. So the best tender wins, independent of the origin of that company. And they said, like, well, should we also be more protectionist as Switzerland? I said, like, please not. Yeah, because I think small countries like Switzerland would lose out. And so there's a big nationalist, protectionist sentiment also rising in Switzerland. But I think if you're not the US or the EU, you don't have the power in the same way. So I'm speaking as an outsider, but not as a third country, because luckily Switzerland is part of the GPA, which at least from a Colin Qingdao perspective, makes it a little bit easier, so to say. But now I would like to add another instrument, and I would call it maybe a protectionist instrument, the FSR, the Foreign Subsidies Directive, and say a couple words to that one. You probably know that the FSR by now, it is meant to be a competition tool, yeah, to create a level playing field between EU and non-EU companies. And it is in force since 2023. But we have a lot of questions. What exactly does it? Who falls under it? We have also reactions, retaliations, especially from China. And so now the Commission has launched a consultation on the FSR guidelines to clarify certain of those questions. So we are awaiting this guideline, and they have to come up with some sort of an answer by January 2026, so very soon. And I just wanted to mention the FSR in an array of different instruments that we're having right now. We have the IPI, the International Procurement Instrument. We have the anti-coercion instrument, and all those instruments, I would say they can be seen in the light of protecting markets, protecting economies, whereas the GPA, as we all know, is quite the opposite: non-discrimination, open access. So there's a conflict, I would say, broiling, and we will see how this will end. Oh, this is it. And so the next one is, I would like to go a little bit deeper into what are actually the goals and obligations under the FSR. Level playing field, we heard that. And as you might know, there are different areas under the FSR. There's a certain mergers and acquisition review that can be done, but most importantly for us here, public procurement, screening of foreign subsidized bidders in large EU public tenders. And then there's also the ex officio investigation. And in fact, we had already 2 of them happening against Chinese companies, wind turbines and Noctec, if I pronounce that correctly, in April 2024. So things are happening. And I'm going to also show you a couple of other investigations under the public procurement scheme today. So companies must notify the Commission if the contract value is at least 250 million euros. And the bidder, and I think most importantly, including group companies and main subcontractors and suppliers, receive at least 4 million in foreign financial contributions from non-EU government during the last 3 years. And I'm also going to talk about what are foreign financial contributions. I think that's a big question because there is a non-exhaustive list. And then there's the possibility to have, the Commission can have a preliminary review, and then it can, if needed, start an in-depth investigation that can take up to 90 days. The measures are exclusion from procurement procedure through the contracting authority and potentially even fines up to 1% of the turnover in the preceding financial year. So there are instruments in place now how to deal with subsidized companies in the EU internal market. So far, that has mainly happened or applied to Chinese companies. And then an important question is also the scope of application. To whom does it apply? Companies, EU-based or not, with non-EU funding. So there's a big question, does it apply to the EEA countries? Well, not to the countries, but to the companies located in those countries. And the same goes for the EFTA states, which means also companies coming or being based in Switzerland. And there will be a question of like, what is the interplay between the FSR and the Colin Qingdao cases that we probably also gonna dive into a little bit later. But one thing that is very important to highlight here, I think, is the FSR applies independently from any existing access agreement with the EU. So that's a big difference. It doesn't matter if a country has an access agreement or not. The FSR has extraterritorial reach. And so far, it was mainly China, but who knows, right? So I think other countries, like, for example, Switzerland, might need to be careful if we have certain trains that we're also delivering to the EU market. We have also train support, infrastructure support, if this is classified as a subsidy, just saying. Then looking a little bit into what are we talking about when we talk about foreign financial contributions. And there are certain categories, or the definition of this is a confer of benefit to an undertaking engaging in an economic activity. And there's 3 categories that I would like to highlight, but it's a non-exclusive list. So there can other, so to say, animals can fall under this financial contribution. The first one is a transfer of funds or liabilities, grants, loans, fiscal incentives, debt forgiveness. And I would like to especially mention the ones that I listed here because I think they're interesting. There might be other interesting categories. But state guarantees to reduce borrowing costs, I think, fall under it. Tax credits for renewable energy projects. Very interesting to make the bridge to the United States, I think. So the IRA has tax credits in place that help promote renewable energy projects and support it, especially production credits. That could qualify as a foreign financial contribution. I think that's almost the most clear-cut case, I would say. The carbon offset credits allocated by governments for free could potentially also fall within this area of application. R&D partnerships with non-EU state funding. So Switzerland has also contributed to some Horizon project. Right now, Switzerland is in the ERC grant, so to say again, but who knows, that might change on a dime. Then domestic preference rules like Buy American, I was just thinking, could that be, is that a subsidy, so to say? I think it's a very difficult question. I would say only if it is coupled with bonus payments or tax rebate or credit, some sort of transfer. Otherwise, is industrial protection policy, so to say. Automatic price adjustment clauses to adjust for inflation. My thought here is that only if the government, so to say, chips in beyond a market logic, like beyond of what inflation would reasonably be priced in the market. But I'm very happy to discuss those points. And then there's also foregoing of revenue, like tax exemption, exclusive rights without adequate remuneration. And then, of course, the purchase of goods and services. But only, I think, if we talk about above market prices, if we have energy supply below cost, for example. So, and then I think coming to the very interesting part of what's actually happening with the FSR, we have had a couple of cases, not like a swapping array, not a whole lot, but we have a few. Apparently, and it's a bit difficult to get these numbers because sources cite very, very different numbers. So for example, how many notifications have been received? There is one source that says by October 2024, the Commission received 1,300 notifications. Okay, something is happening. Doesn't necessarily mean an investigation, of course. And they have been relating to 200 tenders, and now we are already a year later, so that might have doubled or potentially even tripled, we don't know. First enforcement actions were the three here, and highlighted here, of course, the Qingdao Xifang locomotive case. So we see some parallels to what Piotr has spoken to, the Kolin and Qingdao judgments, and we'll probably dive into if they're actually protecting or achieving the same goals, the FSR, with these cases versus the CJ EU judgments. So one here was a tender, a supply of electric trains and related services in Bulgaria. The outcome was that the company withdrew its bid during the investigation. So no need to exclude, the company withdrew. And the same patterns we see with Longqi Solar Technology. In April 2024, there was a solar energy park plan in Romania. There was a consortia, and so here again, there were evidence suggested that the consortium received foreign subsidies exceeding the contract's values, and again, the consortium withdrew, and the same with the Shanghai Electric Group. So we see right now it's mostly China, but as said, that might absolutely change in future. And then we also have certain other things that are not in-depth investigations. I mentioned already the ex officio. I don't have them on the slides, but they're from April 2024. Chinese suppliers of wind turbines for work projects in Spain, France, Romania, Greece, etc. And then also dawn rates of Chinese scanner company NucTech in the Netherlands and Poland. These are the in-depth. But we have a bunch of other things happening around FSR. And one was, for example, in April 1st, China Harbor Engineering was excluded from a tender to build a rail tunnel in Poland. After the Commission scrutinized the impact of foreign subsidies on the bid, the Commission also blocked the unnamed company from bidding to supply IT equipment. And why can it do that? Because the Commission can declare a certain bid irregular. And so what does this irregular mean? I think this looking into the power of the Commission is very important. There's no formal complaint mechanism under the FSR, but the Commission can assess complaints informally. And I think that might also be a certain difference to the Kolin Qingdao judgments. The standard of proof, the discretion that the EU Commission has to assess here certain cases. And if the Commission finds that something is incomplete, it can follow up. And if it finds still insufficient information, that would justify the exclusion of the companies from the tender. So there's a lot of discretion, as you can read here. When is something irregular? What kind of standard of proof do we need? I don't think we know that right now. There's a lot of reactions and retaliations. On the left-hand side, we're not talking about the IPI, but I think it's very important to mention in this context. EU excluded Chinese operators from tenders above 5 million. China retaliated and also said, well, if we are not allowed to supply medical devices into the EU, we do the same for you guys, and also introduced so the exclusion of EU medical devices over 5.3 million from tenders, from Chinese tenders. And then here on the right-hand side, another reaction, which is the Chinese security firm NucTech that I mentioned before, that had a dawn raid done under the ex officio investigation of this FSR, has now launched a lawsuit, and I think it was in a Luxembourg-based general court. So not our European court, so to say, but they're challenging it on a different platform. And I think it will be very interesting to see how this will turn out. China also said very clearly, this is a trade instrument. This has not much to do with procurement. And I think even though I might not share China's views all the time, I do think that they have a good argument that the FSR is actually indeed a trade instrument. So just to summarize here, we're talking about, we have also to consider that we have higher administrative costs. So all the companies have to look and declare what kind of subsidies they have, go down the value chain, which is a lot of effort. We have some legal uncertainty surrounding what is the foreign financial contribution. Potentially, there might also be the risk that it indirectly reduces innovation, like a chilling effect, but we see it's like a lot of technology coming from China and from other countries that might not enter the EU now that we have certain of these measures in place. And then, of course, very, very importantly, trade tensions and protectionism. We have, I believe, currently going on a fight that is played also on the public procurement platform between the large players and in relation to international trade law. And then just want to show this. The United States, of course, has reacted to the FSR. They said they might echo it. They have published this American First Trade Policy report, and they also have threatened to exit the GPA, as you might know. And I think that would be a very difficult and interesting outcome, because then they would potentially also qualify as a third country. And then it gets really interesting if the EU would do anything against the US or just against China. So I think very politically loaded. And as a Swiss, of course, I conclude on this note, is public procurement the Swiss Army knife? It does strategic procurement. It is a competition tool, and now it's also a geopolitical trade tool. I think we need to ask ourselves, what is it? What do we want it to be? Also, when we go into the revision of the EU procurement directives. Thank you.
So thank you all for your brilliant presentations. And I'm going to kick off the Q&A. Piotr, I'm going to start with you. So you were mostly talking about Kolin and Qingdao from a Polish perspective. And it seems to me we have very different approaches in Croatia and in Poland. In Croatia, for the most part, we've seen collectively Kolin and Qingdao as a nuisance of some kind. We acknowledge the judgments, but we, for the most part, pretend they didn't happen. But in Poland, it seems to me that your government is seeing the judgments as an opportunity to do a lot. I'm not saying this is, from my perspective, the right approach, but we recently shared a panel in Warsaw where we discussed the concept of local content, the possibility to promote Polish companies in Polish public procurement procedures, even with regard to companies from other EU countries. So I'd like to hear your thoughts on the subject, and is it feasible in regard to the EU public procurement market and framework?
Yes, it looks like that we are not enough in Poland, and we want more. So that it's not only sufficient that we will reject or exclude economic operators from third countries, but also we do something with, as you said, entities from other member states. But of course, there is a number of issues, and before I will list them just for a bigger picture. And the bigger picture is that basically this is a part of a bigger discussion about a Polonization of Polish economy, right? So, and this is something which quite paradoxically is done by the party that is led by Donald Tusk. So this is the former president of the European Council, who is very much pro-European, but basically knows that in order to win the next election, this is his opinion, he needed to turn right and be more nationalist, also in the economy. The problem is that limiting the access of economic operators from third countries was, as you said, thanks to ECJ judgments. Then with local content, we have, again, a number of judgments, maybe not directly touching upon, but really closely, which go into the opposite direction, right? So basically, the case law will not support that. The second thing is how to define non-Polish companies, non-Polish entities. Third, how to define local content. We have been discussing this in Warsaw, and there are at least 4 concepts for local content. So as a percentage of expenditures in Poland, as a percentage of man hours accounted for in the country, then the share of domestic suppliers, and the most general one, added value for the Polish economy. So I think it's not feasible, actually, and we will be left with only some soft measures made by the contracting authorities. But the whole thing, and this is as a summary of my response, is that as one of the professors of economy said during our conference in Warsaw, there are no single reliable study from the perspective of economy that local content requirements are beneficial for the economy of a given state. But we are doing that because others are doing the same, but I think it's not a good reason. Thank you.
A question for Chris. So you were discussing international procurement and international trade agreements, international procurement obligations. So I was wondering what your thoughts are on the state now and the future of the WTO GPA, because when administrations change in the US, we can hear or we can read a lot of statements saying, well, now is the time to leave the GPA is no good, it's not beneficial for the US economy. So if something like this did happen, it could snowball and we can have a real crisis in the GPA. And I was wondering, do you think this is all just political bluster, or is there something to it?
So first, Trump definitely hates multilateral, plurilateral agreements because it means the United States has less power as an 800-pound gorilla. In a multilateral, plurilateral arrangement, the United States has less power than it has in a bilateral arrangement. So he would favor getting out of plurilateral agreements like the GPA. What happened in his first administration was diplomatic genius. The Canadians who were treated, so all of you are aware of the idea in international trade agreements of reciprocity in procurement. It means that I'm going to open up my procurement market if you open up yours. It is a concept with enormous elasticity. It doesn't really mean reciprocity. It means sort of a loose reciprocity. And the Trump administration introduced the idea of strict reciprocity. Every dollar that they opened up to, say, Canada, Canada would have to open up a dollar as well. Well, the Canadian economy is only 1/10 the size of the US economy. Canada is only 1/10 the size of the United States. We are close and loving neighbors. We never say that out loud. No one ever says that in the discourse between Canada and the United States. No one knows it. No one talks about it. It's just a thing, okay? But Trump wanted to make it strict dollar for dollar. So those of us in the procurement community were trying to figure out how this worked. Would you only allow Canada into U.S. procurement every second Tuesday? How would you do it exactly if it was strict dollar for dollar? The Canadians were really angry. In fact, the Canadian foreign minister said in the Toronto financial press, this is the most offensive thing he'd ever seen in international negotiations, which is saying a lot. But that was interesting. It illustrates for you how much the Canadians hate to be told that they're the little brothers. So the Canadians waited and waited and waited, and in the very last minute in the negotiations of the US, Mexico, Canada agreement, very important regional agreement between US, Mexico, and Canada, the Canadians withdrew from Chapter 13, which is the procurement chapter. And they did it at the last minute. You know it's at the last minute because it was done by a footnote. A footnote at the bottom says, oh, here's Chapter 13 on government procurement, but it doesn't apply to Canada. Canada just pulled out all of a sudden and shocked the United States by doing that. It was a masterstroke. It meant that if the United States is to access, to answer your question, if the United States is to access Canadian public procurement markets, which are important, the United States vendors can only do so under the GPA. So Canada not only stuck its finger in the eye of the United States by withdrawing, but it also forced the Trump administration to remain locked in the GPA, because if the United States leaves the GPA, no access to Canada. And that would be unacceptable politically. So to answer your question, for these tactical reasons, I think the United States will remain within the GPA.
Okay. And a question for Desiree. So, of course, the FSR, IPI, ACI, and so on, all of these legal instruments, we have a lot of acronyms here. But let's see what is the interplay here between the FSR that you were talking about and Colin and Qingdao. You can make an argument they are complementary, as you said, I think, in your presentation. But you can also make an argument that they are at odds, because if you start to exclude a lot, maybe you won't be able to use the FSR on third countries, but you can use it on the US, Switzerland, and so on. So what are your thoughts on the coherence? This is a buzzword we are hearing a lot of in the recent weeks and months. So is there a coherence between the judgments and the instruments, in particular the FSR?
Thank you, Marco. I came prepared. I don't know if it covers all the grounds, but I think in certain ways they are, but they also differ, and therefore the outcome differs. And so I think one very important difference is the goal. So the FSR addresses market distortions, right, in an internal market, whereas Colin Qingdao are about market access. And there's a difference, entering a market and distortions within a market. So I think that's a different rationale. And as I said, like another difference is that Colin Qingdao look at without access agreement, what happens to third countries then. The FSR doesn't discriminate in the same way. It could be applied only to ones that have an access agreement, but it could also be applied to those without one, I think. And foreign financial contribution, I would say, is also much broader than public procurement. So it goes wider. There's a bigger scope. And I addressed it a little bit during the presentation. I think the Commission has very wide discretion in launching investigations under the FSR. And I believe it's a little bit more restricted under Colin Qingdao. There are some stricter rules that we know in public procurement, transparency, etc. But very interestingly, the US also said they have exclusive competence under the Common Commercial Policy, right? And that is, again, a question of interpretation, or like when do they draw the exclusive competence and make it very clear away from the member states. Another thing, the last one here mentioned, is third country operators under Colin Qingdao cannot rely on EU equal treatment rights. That's a big issue, as we all know. And I think the distorted foreign subsidies from third countries with or without access agreement are actually treated the same. So there's a certain, I would say, equal treatment happening that we have less under Colin Qingdao. So in some, I think they have a different logic that can produce different outcomes, and definitely legal uncertainty, what happens with those cases, how they look like, I cannot currently tell you, but I think that the logic and reasoning rationale is different, and therefore we will also have different outcomes.
So we have time for a question from the audience. Anybody? Or are we too hungry to ask questions? Yeah, of course. Yeah.
Is there a question over here? Okay. So I have to say, as an American coming from the outside to these discussions, it's just bizarre that. So here's the question I have. So with regards to calling in Qingdao, for example, if the goal, so Americans are constantly stunned that the European Union and the Court of Justice for the European Union, their avowed goal is to further competition within the European Union, not to build the best goddamn procurement system in the world. That's their job. Their job should be to build the best procurement system in the world, not to perpetuate a European competitive market. That's not their job, because they're telling, I spent 10 years with Mikhail. Michael and I were working for 10 years on the UN procurement law. So I got an insight on his perspectives. He never ever said, oh, the European Union directives are a great idea because they're perpetuating a European market. He always said, this is how a procurement system should work, because that's his job. He knows what his job is. So there's a disconnect between the member states, which are trying to build great procurement systems, and the European Union, which has a different goal. He told the story. He said, I don't know, did you say, who said they just forgot an element because they didn't understand the procurement system? The policymakers in Brussels are not there to build a brigade procurement system, and it creates a fundamental illegitimacy in Brussels as a result. And by the way, we understand this because we have a supervisory appellate court called the Federal Circuit that oversees our procurement system. And we remind them constantly, if you guys mess up, if you mess up our procurement system, we will ridicule you. And the judges, as a result, are very, very careful. They hire clerks who understand procurement. They take the briefs in. They take amici briefs in as well. They're very careful not to screw up the procurement system. But you guys never turn around and say to Brussels, you're screwing up our procurement systems. Stop it. Stop it. You can't do that. And we as Americans don't understand that, because if you don't start saying that out loud, Brussels will continue this nonsense of imposing rules on you that are not about procurement. But your job is to do the best possible service, best procurement system to serve the men, women, and children of your countries. And if Brussels doesn't get that, then Brussels is in trouble. That's why Brexit occurred. Brussels didn't understand that, and they have to understand that. So I think I'm more controversial than Michael.
No, I fully agree with Chris. The thing is, first of all, I think the ECJ doesn't understand procurement. That's the first basic element. It's they see themselves, at least I've now, as an agent now more than 30 years of practice with the ECJ, they see themselves as a political creature. And one of the missions is that they want to create new law if they perceive that Brussels, the legislator, is not doing enough. So they see themselves in a kind of, I help them out if they don't get it right. But they never pose themselves the question, do we know what's right? That's the first thing. So calling Qingdao, I think for everybody came as a surprise. You know, you ask, are they to be excluded? And they said, oh, they don't have a legal standing. So, oh, what the guy? This was not the question. So, so this came out of the blue. The thing is that I'm telling them that they don't get it right. Yeah, there is the mechanism in Brussels, which is now a problem right now. You have the Commission, which internally is split between different factions. You have DG Santé, you have DG Grow, you have DG Trade, and so on. they need to compromise internally when they put a proposal on the table, which is muddying down the water already. And DG Grow sometimes is not very strong. You know, for example, you see it now in the upcoming Industrial Accelerator Act, where they're going to lose. In the Critical Medicines Act, where industrial policy with procurement, this is nightmare, this is stupidity. And so first of all, the proposal is not the optimal stuff. Then it goes to the council. In the council, you have a huge pressure because there is a president in the seat who wants to sell a success. So there is a huge pressure, which leads to a rush process. Have a look at the evaluation process, which was a rush job. Yeah. And then you have the European Parliament, which is sometimes an unguided missile. And it depends on who is going to be the rapporteur. If he, she has their own agenda, what is the agenda? Does it fit with the overall legislative process and so on? And this, I think, more and more, having seen that now for a repeated time, is a huge process because, as you rightly said, they are not pacing themselves the fundamental question, what should be the best outcome for the process? And that's the issue. And this is something we cannot change in a short run. We need to constantly tell them, okay, you need to get it right. Otherwise, we're going to burning money all the time, each and every procedure. Look at the evaluation process, see how the figures, how much a procedure costs right now. It went up from 34,000 euros to 43,000 on average per procedure, 43,000 euros. This is a lot of money. And I question if in each and every procedure, the transactions, the gains, the transparency gains outweigh the cost of the procedure. And if they outweigh the procedure, we need to ask ourselves, what economic sense does it make if you just burn the money for the sake of the process? And that's, I think, those are such a lot of questions we need to tackle all the time. And yeah, unfortunately, there are not that many who are prepared to listen. That's unfortunate. So, yeah.
I'm really surprised by this line of reasoning because we all know the European institutions are infallible. So maybe on that note, we should go to lunch, people.
Che questa? Evacuici 40 samo. 40 evacuici Saras Yaga. Da.
Je čisto, da? Niko nije. Daniela ne treba, jel da? Danieli, Dobro. Ova vrata otvoriti tu. Ova vanjska ne. Ništa onda prozor, evo vidite tamo.
So it's almost like an energy. And you can exact have also have you'll have distortion in all the distortion just say it's one distortion and the other
Ovako nekako. Okay, we can start. Hello, everyone, and welcome back. I hope you all enjoyed your lunch break. We are now continuing with our conference program with a panel session titled Green and Socially Responsible New Approaches. This session will explore how sustainability and social responsibility are reshaping the way public procurement and policy are designed and implemented. We are privileged to have with us distinguished experts who will share their insights on this very relevant and timely topic. Now it's my pleasure to introduce our panelists. First, Professor Roberto Caranta, full professor of administrative law at the University of Turin in Italy. Professor Caranta's work focuses on public procurement, particularly sustainable procurement and remedies, as well as EU and comparative administrative law with a special emphasis on judicial protection. Next, we have Mrs. Eva Ružić, research and teaching assistant in the Department of Administrative Science at the Faculty of Law, University of Rijeka. Her work focuses on public procurement law, administrative governance, and the relationship between national and EU legal frameworks. And finally, Professor Sarah Schoenmakers, Professor of European Economic Law at Maastricht University, endowed Professor of EU Law at the Open Universiteit, and Professor of Construction Law at Hasselt University. Her research concentrates on European public procurement law, free movement law, and the link between EU economic law and culture. Although Professor Schoenmakers couldn't join us in person today, we'll have the opportunity to hear her insights through the recorded presentation. So to begin, I'll first invite Professor Roberto Caranta to share his presentation on what future for social responsibility and sustainable public procurement. Almost.
Thank you very much, Daniela. How many minutes? 18, something like that. But it's going to work. Okay, so I was thinking this slot, this specific lot in academic parlance is known as the deathbed. Because, thank you, Marco, thank you, Maya. The food was excellent. My Weight Watchers program has been derailed for the next decade, but I think I'm not the only one feeling a little bit. So I decided, no, I'm not so sure that socially responsible procurement will be enough. And I'm really super worried about Michael. I want to say something that is really outrageous so that we can start the debate. So I'm taking it a bit more generally. So you have socially responsible procurement. It is there. I've just added it, but it's wider on SPP. So we are expert, we already know. So all the time when we were focusing on what we wanted to buy, basically from the 80s, not before, because before public procurement was an economic policy level, the idea was that you have rules about procedure. Why do we have rules about procedure? Well, if you ask Christopher, he would say, yeah, because this is the best experience. We had already it in the US many hundreds years ago, and now you are just following up. Why procedures? You don't have procedures in the private sector. Well, because here we are worried about something else, something that is not what we buy, but agency. Someone is going to steal the money, and I come from Italy, so I know what I'm talking about. So a lot of rules, but just to constrain the discretion. not much room for sustainability. Then you have the 2018 directives, not super ambitious, but the proposal was totally not ambitious, with a few points mainly empowering contracting authorities. Then we have a general principle, we have the Green Deal. We started moving towards what to buy. Mandatory public procurement. So last week, it was a list of 60 directives, regulations on different aspects, not yet listing the critical medicines. Then it will be 61, 62, and so on. What is the idea? The idea is that public procurement is a lot of money. I would add something. It's not so much that public procurement, yes, it's a lot of money, but that's not just that. Is that states do not have much other money. So it's either public procurement or salaries. Salaries, you can't do much. So it's not just a coincidence that they think about public procurement 2 years ago, because, okay, we don't like Trump. And this is a reciprocal. He doesn't like us. Well, Biden didn't hate us, but it put this Inflation Reduction Act that was giving a lot of money to companies on sustainability. And you know, companies, the old times it was peasants. Peasants were always complaining about the weather, about taxation. Now it's not just peasants, it's also companies. They were complaining and saying, we want to move. We want to go to the United States because they are giving money. And what was the reaction in Europe? Well, we don't have that much money to outgun this, but maybe some aid and maybe starts using public procurement. Now, there is a lot of aspects, but now we have the reform. So I want to talk about the reform. And I have 5 points to touch briefly, to say something that it will be, I hope, shocking. So, buttress the freedom of the contracting authorities to choose, and this not so much against sectoral legislation. It's more about the case law. The case law is trying, Court of Justice, but also in some member states, Spain, for instance, is trying to limit choices because of this big holy cow. What is the holy cow? Draghi. Competition. Competition, is it really what we need to achieve? A colleague a few years ago was going around to conferences saying, one more competitor, 10% less cost. Wow, 2 competitors, 20%. Now the valuation is saying 2.5. I'm not doing numbers, so I don't know how do you calculate that. But it is really interesting. I was talking with Francois this morning, or was it yesterday? But he was saying, okay, a company in works to make a profit needed to win one contract every 7, let's say, participation. And so we are wondering, oh, competition, we have less and less companies. Why we don't have 10 companies for each procurement? Well, if François is right, if we had 10 companies for each procurement, 3 will be bankrupt in less than 1 year because they will not get 1 on 7 contract. So I think it is really necessary to start saying that, yes, contracting authorities, they can make choices, and any choice is limiting or changing the competition. If you are asking for biological veggies for your kitchen, of course, those not growing biologically, they are out. But if you are not precising, it will be those growing biological that will be out, because they will be about price. They will not be competitive. So I think really this is in the concession directives, but I think we really need to put this in the directive. It is for the contracting authority, unless there is overriding legislation, to decide what they want, which level of quality, safety, and so on they want to achieve in public procurement. And this can't be considered to be artificially narrowing competition. Here the important word is artificial. Link to the subject matter. Of course, it was important, Concordia Bus, to starting widening. Do we need it now that we have this idea of life cycle, considering everything? So the directive, Recital 97, when looking into what is not linked to the subject matter, the answer was, okay, general corporate social policy. Oh, great. And that's the only thing that is out according the directive. Just one thing? Well, we have, I don't know what will happen with Omnibus, but we still have the corporate sustainability due diligence. And I think the recital is almost hilarious, because they are saying, of course, for those companies, economic operators, sorry, for whom is mandatory, this you must consider, but for the other, you might use it in a performance condition, even in a work criteria, and then you put in the recitals, maybe we should coordinate with the procurement directive. There is no way to coordinate with the procurement directive. If you go down this way, you forget about this idea. Is that, being a lawyer is a privilege, because we are really the last defender of the Western logical tradition. You can't have something that is white and non-white or black at the same time. You can stretch, but still there is logic. Then competition, I've already talked. I would just add a few words about the 60, 61, 62, 63. How do we try to make this working in public procurement? Well, of course, it is complicated. I don't know. I talk with people from public procurement contracting authorities. Of course, they are complaining, but they don't look to me as idiots. I think a lot of them, a lot of you, by the way, can really work with the batteries regulation when buying electric buses. Maybe not if you have a law degree, but you will have an engineer. And this engineer will be a specialist. Of course, then you say, yeah, but in the small municipalities up in the mountains. How many electric buses are small municipalities are in the mountains buying every year? Not just to know. There is a problem. I think it is a little bit inflated, but it is there. And now there is the reform. And the reform, well, of course, I'm saying this because we don't have the new directives. It's like hope. It's kind of like marriage. You pile up hopes, and until you get married. Then you reckon with reality. But now it's the good moment. It's romantic. It's really thinking, oh, what I would want from these directives. Well, whom not to buy from? CSDD, looking into integrity. I think that could go into the directives. Yesterday, Christopher was talking about exclusions and things. I think we can start weaning the procurement market from the bad people. Otherwise, the competitive pressure on the good people will be just too strong. There is already there for taxation, for social contribution. What is the problem? The problem is how we know about these breaches. This is data. This is the next panel. The problem is sectoral. Batteries, electric vehicles, medicines, those things that go under the net zero industry. Well, you can't put everything into the directives. What we might have in the directives, I think we should have an indication. Why? Because Michael was explaining how it works making a directive, but it was being a bit shy. He was not mentioning, and then it comes the trialogue. All together, working well in the night, trying to reach a compromise. And now, I don't think it's a problem having 61 regulations or directives. I think the problem is that each of them is taking a different or slightly different approach to what is really the same problem. So there should, what we might have in the directive reform is to streamlining. Okay, contract performance clauses, you use them in a certain way. Our criteria, it can be different every time. 20%, 30%. Yeah, but if it costs more than 10%, no, if it costs more than 50%. The directives might be the place where you give some indication. What is the problem? The problem is that the 60 instruments are already there. So one option is trying the omnibus. My opinion is that this omnibus we are already talking about, corporate sustainability due diligence, is not working so smoothly. But we need some ingenuity to streamline the process. Because when I was talking about sustainable public procurement, good colleagues and friends, Pedro, was telling me, oh, wow, you are charging too much public procurement. Well, oh, the same the Court of Auditors. Well, come on, maybe tomorrow is not going to be about let's save the seals or let's be nice to workers in Bangladesh. But for sure, there will be some resilience, some security, something that will be charged into public procurement. So we really need to find an approach which is consistent and will make it easier for contracting authority to understand how all the mechanism is. So still having provisions outside the directives, but having some kind of a good methodology to develop these provisions. And the remedies, okay, this was already this morning, so just one pinch of salt. Well, the floodgates, so many new cases. Well, it was already said, NGOs, they are not going to challenge each and every public procurement. They will be focusing on something. But what is a little bit, after a few years in law, kind of scary, as lawyers, we should push back against this trend that is saying law is making stuff too difficult. Remedies are making working impossible. Well, there must be a reason why there are remedies, why we have rules. And this is not public procurement. I'm not just worried, I might retire in a few years, but I'm not just worried about the future, Marco's future. If we go down this road, but why do we have administrative law in the first place? Do we need, I just can listen to the economist telling, is it efficient to have public procurement? Is it efficient to have EU public procurement? Is it efficient to have administrative law in the first place? Is it efficient to have the state in the first place? So I'm just cautioning about a snowballing effect of saying that, okay, all these rules, they are just bad. We could do without rules. Maybe I'm a little bit path dependent, but I think if we have developed the modern state in the past 500 years, and in Europe, not in the United States, and public procurement is part of the modern state, I'm really a bit worried about, going beyond that. Thank you a lot for listening.
Okay. Hi, everyone. I would like to begin by saying that it is a great pleasure to be a part of this conference, and I would like to thank the organizers for having me. And I am deeply honored to share some reflections on the evolving nature of public procurement and its growing alignment with social responsibility. So the title of my presentation today will be Public Procurement with a Purpose, Understanding the Shift Towards Social Responsibility. And I will try my best to capture a development that is far from accidental. It reflects not only a change in regulatory priorities, but also a deeper transformation in the way that we can understand the purpose of governance itself. So my actual goal is to to actually give you the purpose of my presentation, and that is to explore how and why public procurement evolved from economic efficiency to social responsibility. And in order to do that, I should actually cover these historical and conceptual foundations. After that, I will try to explain theoretical framework and administrative doctrines and how are those two connected to public procurement. After that, I will say something about European and national framework, because I have to touch upon the case of Croatia since we are here today in Zagreb. And I will refer to current challenges and future outlook. So it is very interesting to see that this sustainable public procurement actually reflects the socially responsible public procurement and green public procurement. And when we see the historical development of these two subjects, we can actually say that socially responsible public procurement was way before green public procurement. And that is very interesting because in today's circumstances, we do see that European Union puts bigger emphasis on green public procurement. So when we talk about socially responsible public procurement, this is the definition that I am referring to. That is the integration of social objectives into process of purchasing goods, services, or works with public funds. And I think that is, we can give that definition because we can consider public procurement as a highly adaptable instrument. And we often employ public procurement to achieve specific policy goals, whether other forms of regulation are not feasible or appropriate. So we use public procurement to achieve broader societal goals. With that, we should actually see something that happened throughout the history, because procurement was and still is a reflection of social needs and public values that are given to that period of time. So socially responsible public procurement became relevant around 19th century, when there has been the development of welfare state. And with that, public procurement served as early inclusion of social aims. And with that, and with public procurement procedures, we could tackle the specific outcomes of welfare state, and this is how it was used. And this actually affirms our this actually becomes clear in National Industrial Recovery Act, that actually recognized public procurement as a way to achieve broader societal goals than just to do this specific procedure. We did have this perception of public procurement, but this changed during 1970s, when there was an economic crisis, and this actually shifted the focus dramatically, because the values of that period of time became cost efficiency and fiscal discipline. So with that, public procurement became a means to achieve value for money and the lowest price possible. And actually, in that period of time, we can actually see that this social agenda stopped. And this actually continued with WTO integration, because we see that the purpose of this integration of public procurement became the expenditure of international trade. But with that, we do see that there is a principle of non-discrimination. and the focus was on economic criteria because they didn't want to include socially relevant criteria because they were actually scared that they will do something about this non-discrimination principle that was leading inside the WTO. So how does that actually apply to administrative doctrines? Administrative doctrines are ideas and system of ideas about desirable methods of action in public management grounded in public values and experience. And with that, we can actually see that the doctrines evolve in response to broader societal, economic, and social shifts. And they are shaped and shape the expectations of societies that societies placed on the government. So with that, public procurement actually mirrors the social values of certain period of time. So we can see that when the welfare state was very on the price and with new public administration as the dominant administrative doctrine, we see that public procurement was taking into account social inclusion and protection of vulnerable groups. But when the regulatory state came into force, and with that new public management, we see the shift in perceiving public procurement, and dominant values are efficiency and competition. And my main point is that we cannot actually take into consideration just economic theories. Why is that so? So economic theories, we can actually say that they are public interest theory and private interest theory. So public interest theory actually relies on values representing the common good, and they do not make distinction between social and operational goals, which is very problematic when it comes to public procurement and socially responsible elements. In contrast, the private interest theory argues that regulators are influenced by private interests, and the social aspects are only there if they align with private interests. But with those two theories, we do see a lack of socially responsible dimension. This socially responsible dimension is the main part of the welfare state theory. So with that being said, if we want to see how is socially responsible procurement connected to the specific period of time and specific state, we must take welfare state theory into account and see actually which welfare state theory is dominant inside a certain country. So with that, we do see the causal linkage, because if we want to see the theories that are prevailing, we should see the welfare state theory in certain period and also in certain country to see those differences and take it into account while regulating and making the social responsible part of procurement possible. Okay, so I want to touch upon a European framework. We do see the gradual inclusion of social objectives inside the European Union, and this is actually throughout the good governance administrative doctrine, which is today present in many directives and in many regulatory frameworks. However, when it comes to socially responsible public procurement, we do see soft law dominance. I put on some recommendations and some documents that are very important in European context. And we do have one mandatory horizontal social clause, but when it comes to the impact of this social clause, it is very limited. Why is that so? Because it proposes that member states shall take appropriate measures, but with this transposition laws that are taking into account a directive on public procurement, this obligation is often passed to the contracting authorities, which then they pass it to other authorities. And this actually is problematic because we don't have somebody who is responsible when it comes to implementing this horizontal social clause. Also, the problematic part is this appropriate measures, because it doesn't define the appropriate measures that should be taken into account. And however, when we think about this horizontal social clause and also the soft law dominance, we can actually conclude that there is divergent implementation across member states. This is actually due to different political systems and varying institutional capacities. And my point is that these different political systems should be taken into account in order to perceive and in order to make socially responsible public procurement greater. We also have a lack of data because we don't have the volume of public procurement and the data when it comes to this, because there is no uniform system to collect data. We do have TED that allows identification on tenders that are using meet criteria, but it is impossible from TED to determine if a tender includes social criteria or green criteria or innovation criteria. We do have to touch upon Croatia. So in Croatia, the situation actually reflects this broader European picture. And we do not have, in annual statistical reports, we do not have the category of socially responsible public procurement because there is no reliable data to connect this with measurements. And we do have new amendments of Croatian Public Procurement Act that are still in the process of public consultation, but they primarily address digitalization and the reduction of administrative burdens. And also, we do have appeal-free reduction, which can lead to improvement when it comes to fees that are touching upon socially responsible public procurement. And green procurement is promoted way more than us SRPP. So these are the current challenges and reflections for future. So there is significant differences among member states in terms of implementation of socially responsible criteria, which must be taken into account if we want to make something greater. How is that? We should take those cultural differences, also political differences, and make them a starting point to build something that is more, let's say, sustainable. There is complexity of public procurement procedures that creates resistance among contracting authorities. Measurement and evaluation of SRPP are still underdeveloped. And with that, Professor Hartleb actually proposed index as a possible measure of improvement. So this index should be applicable to all categories that are economical categories, but this index actually measures substance, potential impact, and enforcement. Measures substance in a sense that it goes inside and sees what is actual data that is measuring. Potential impact, in a sense, is it reflecting only one group of people, special vulnerable groups of people in the society, and the enforcement, if it's mandatory or not. And this index was actually applied in Germany and in France. And it showed that Germany, for instance, has a stronger focus on individual social rights, and France has more oriented index towards social solidarity and equality. And this is something that should be a starting point for future when it comes to sustainable and socially responsible public procurement. Also, those cultural and institutional dimensions have an impact and cannot be ignored. I said it is very important how member states are perceiving welfare state. And with that, we can see that there are significant differences between member states. It is not the same if a certain member state has the, I don't know, neoliberal perception of welfare state, where they are justifying social expenditures as an investment in people, or do they have a modern perception of the welfare state? So this is actually very important when it comes to socially responsible public procurement. And I want to conclude with this thought. So the shift towards socially responsible procurement marks a transition from pursuing economic efficiency to creating genuine public value. Thank you.
Thank you.
Thank you, Eva. I'm sorry, just a second. Unfortunately, Sarah wasn't able to join us today, but she was kind enough to record her presentation, so I'm going to attempt to play her video for you.
In this presentation, national or subnational out. Hello everyone, I'm Sarah Schoenmakers and I'm going to say a little bit more about the link between public procurement and financial and funding. Rules, specifically to determine whether financial and funding rules can have a steering effect on sustainable public procurement. If you look at public procurement in general, then you have the classic public procurement as a first type. I called it in this presentation national or subnational public procurement, which is the procurement based on Directive 2014/24. In this public procurement directive, you have the most economically advantageous tender criterion as the award criteria that is always used. But as we all know, there is in principle no obligation to consider wider strategic sustainable goals in this public procurement directive. Now, we also have public procurement that is EU institutional procurement. I also call this another form of direct funding because the money streams actually go from either, in the previous case, the money went from the national authorities to the economic operators, and here you have directly money that is spent, but then by the EU institutions. And that EU institutional procurement takes place on the basis of the financial rules. The latest version is the 2024/2509 regulation. EU public procurement on this basis means that the Commission actually is implementing the budget. And this is also called direct management because the Commission is actually directly dealing with EU funds. This direct management can take different forms, such as the provision of subsidies, but also public procurement can be a possibility there, where the Commission actually conducts a public procurement procedure and issues a call for tenders. Think about calls for tenders to do research for the European Commission, for example, and then the Commission is also signing the contract. This whole public procurement system is actually more or less based on the same rules as the normal, the classic procurement based on Directive 2014/24. And you also see that whenever there is a case before the general court, then it will always interpret the rules of this regulation in conformity with how the general rules of public procurement in the classic 2014-24 directive are interpreted. Now, if you look at this financial directive, then also there you see that in the recitals it is mentioned that progress should be made towards the implementation of greening aspects, that there are some specific rules relating to the fact that the budget should be implemented on the basis of the principles of sound financial management, which actually includes the principle of efficiency, so that you have to make sure that the best relationship exists between the resources that are actually employed and the achievement of objectives that one is after. And in Article 33 of this directive, it is explicitly stated that all these programs and activities on the basis of this regulation should be, where feasible, happen without doing harm to the environmental objectives of climate change mitigation, climate change adaptation, and so on. So it is not allowed to do a significant harm to climate, but where feasible. Again, no real hardcore obligation actually to have sustainability included in these types of public procurement. Now, next to these two different types of direct funding, we also have public procurement and indirect funding, which actually means that the funds, the EU money, is implemented and administered by the European Commission and national and regional authorities. So that means that certain tasks of the budget implementation, the EU budget implementation, are delegated to the member state level. That means concretely that national administrations actually choose which projects to finance. They also take care of the day-to-day management of these finances. And the Commission is there to ensure that the projects are successfully concluded and that the money is well spent. So also here you see that the Member States and the Commission will have to ensure that the projects are successfully concluded and that the money is well spent, and that this all happens in line with the principles of transparency, non-discrimination, and sound financial management. Now, 70% of the EU programs is actually run. It is running on the basis of this shared budgetary management under the umbrella of the cohesion policy, which you can find in Regulation 2021-1060. That regulation lays down common provisions on different funds, for example, the Cohesion Fund, the Asylum Fund, and the Social Plus Fund. And almost half of all cohesion funds, and then we are talking about close to 200 billion euros in each programming period, is disbursed on the basis of public procurement procedures. So these EU funds can also be disbursed on the basis of other rationales, such as subsidies. But more than half, or almost half, I should say, is occurring on the basis of public procurement. So what happens? The recipient of such fund is a contracting authority, and a contracting authority is then using a public procurement procedure to actually find a private partner on the basis of the classic directive 2014-24. So you see that these EU rules for cohesion, Regulation 2021-1060, and public procurement actually have the same objective, namely ensuring that public money is well spent, that it is spent efficiently and effectively. And in these funding regulations, you see that there are some enabling conditions that are called prerequisite conditions to actually be able to implement these funds. And if these conditions are not fulfilled, then the expenditure will not be reimbursed by the Commission. So normally the contracting authorities spend money and give the money to the private parties, but if these prerequisites are not lived up to, then the Commission is not going to step in to reimburse the money that is spent. So what are these prerequisites, for example, that these member states have to collect reliable data, that they have to give information about the number of SMEs that participated, that they also have to inform how many direct bidders there were actually. So it is a lot about monitoring. And in a document, a Commission staff working document of 2023, it was indicated that all member states have actually fulfilled all these enabling conditions. And then you also see that in general, there is hence no obligation to procure strategically, but that the overall element there is still the do not do any significant harm to the climate that is there. So the question is, can there then be any policy steering if there's no obligation to procure sustainable? Well, of course, contracting authorities always have to respect the law, otherwise there can be an infringement procedure. And you also see that in this funding regulation 2020-1060, in recital 6, there are some objectives that are to be pursued in the framework of sustainable development. Namely, the funds should contribute to mainstreaming climate actions, to the achievement of an overall target of 30% of the union budget expenditure to be invested in climate objectives and so on, that these funds should support a greener and more resilient Europe and so on. And then you see also in these fulfillment criteria that one should comply with the 2020 binding national renewable energy target. So you see, for example, that in the cohesion fund, there's this target that there should be a 37% of the cohesion fund that should be used to support the achievement of climate objectives. So that means that compliance with these objectives is fundamental to obtain the EU funding. So you could say that this EU funding is steering the behavior of the beneficiaries to a certain extent. So again, we are talking about there can be no significant harm when implementing projects. One have to comply with general sustainable policy objectives, and when one has to fulfill also these thematic conditions, these prerequisites. But on the other hand, you see that research has shown that all this co-funding did not really increase green public procurement. So when you are talking about indirect funding, what we were dealing with now, only 2.7% increase of sustainable procurement we have there. And that might seem a lot, but you see that the only reason why one is trying to contribute to climate objectives is for the money, for the financial incentives, and not really because of the green objectives itself. So what do we have then? Is there anything that we have to steer the behavior of contracting authorities into a more sustainable direction? Well, if you go back again to this financial regulation that we have, then you see that it is indicated that member states are expected to ensure that they implement the actions financed from the union budget correctly, that they protect the financial interests of the union by correcting irregularities and fraud. So that means that member states are required to do some ex ante and ex post controls and are allowed, even required, to recover funds that are unduly paid. So they have to do controls, they have to do audits and recovery. And if member states take these actions, then the European Commission will not really step in anymore. So if you look at Regulation 2021-1016 in concretely, then you see in Article 103 that member states are required to protect the interests of the Union by applying financial corrections and even by cancelling all the support, or at least part of the support that is coming from the funds, if the Commission has declared that certain expenditure has been irregular. So that means that if there is a breach resulting from an act or an omission by an economic operator, which actually is going to influence the EU budget, this can happen. And on the basis of Article 104, you also see that if there is an irregularity by a member state, so for example, if something went wrong but it was not detected by the member state, or if the member state failed to take the necessary steps, then the Commission will step in and a member state cannot get any reimbursement of the expenditure that it actually did. So more concretely, we have a Commission decision of 14 May 2019 laying down the guidelines for determining these financial corrections to be made to expenditure financed by the Union for non-compliance with the applicable rules on public procurement. And that is a document that we have to increase legal certainty for member states, also to ensure proportionality when corrections are imposed, and to promote consistency of treatment in such situations. So, for example, this document says that when the award criteria that are mentioned in the public procurement procedure, when those are not followed, so for example, if the most economically advantageous tender criterion gives a certain percent of the points to green elements, but that is not followed, then there can be a correction weight of 10%. And that correction weight can even be higher, for example, 25%, if there were, for example, unjustified preferences, so that you actually have a certain discriminatory element attached to that. So that means that when the contracting authority is not correctly applying its own award criteria, not only other economic operators can complain and sue and say, for example, we want to get damage compensation based on the classic remedies directive, but it can also be so that these member states are required to reimburse the program, or that they may not get any reimbursement themselves in the first place. So that means that while financial rules may not really steer the behavior of member states or of contracting authorities in a more sustainable direction, they may nevertheless contribute to a certain extent to ensure that contracting authorities live up to sustainable elements if these are referred to in the award criteria, and that on the basis of these financial corrections, for example, that can be made, and also on the basis of for example, the other elements that I was referring to before, the more explicit policy steering, the do not significant harm elements that is actually referred to in these funding rules. So there's no real direct and specific and concrete steering that is possible, but there's at least an indirect steering of the behavior of national contracting authorities in public procurement procedures for sustainable reasons. Thank you very much. Have a nice afternoon, and thank you for having me. Bye-bye.
Thank you very much to all our speakers for that insightful contributions. We'll now move to the panel discussion and take this opportunity to explore some of the issues you raised in more depth. I have few questions for our panelists, so I'll start with Professor Karanta first. In your presentation, you emphasized that EU law has traditionally focused on how to buy, but that we are now moving toward a debate on what to buy, especially under the European Green Deal. How do you see this shift shaping the future of EU public procurement? Will sustainability and social responsibility become binding principles or remain more of a policy aspiration?
Well, as I was saying before, I think that certainty is important. And I'm maybe contradicting something I said before, fair competition is important. My accent is on fair. So we have already in the directive, if you are not paying taxes or social contribution, you should be out of the competition. Why this? Because otherwise, a dishonest economic operator will have a competitive advantage over an honest economic operator. But this is the same concerning all other costs for a firm. Compliance with environmental legislation is a cost for a firm. Is a reason why a lot of companies decided to delocalize their production out of the United States, out of Europe. So, if you say, oh no, I can't care whether they are complying with this, you put a premium for breaching the rules. Those breaching the rules will have a competitive advantage towards those not breaching the rules. So my impression is that the present system with Article 18, Article 56 and Article 57 4A is bit weak. There is a lot of may. Of course, there is a lot of may because we can't totally forget practicalities. The reason why there is a lot of may is because we don't have enough information. But faced with the thing that we don't have, we contracting authorities, they don't have enough information. We have two approaches. One approach is we don't have enough information, so we don't care. And the problem is that a dishonest economic operator will have a benefit. And the other approach is, okay, let's make this information available, which is for the next panel to discuss. So what I hope, and I might be disappointed from the reform, is that really we start having more of those information about economic operators, which, by the way, is a problem also within a number of the member states. I just name Italy. We have dishonest operators going around the country and cheating different economic operators each time. We don't have a serious system for having feedbacks on how contracts were really performed. And often contracting authorities are kind of reluctant to say, no, this was not performed that well because this means litigation and so on and so forth. Well, but this has a huge cost for the whole system. Since, Christmas, winter are approaching. Well, in Turin, we had all times, we still had no snow in town, we had the company charged with cleaning the streets that was not working well. And when challenged, their answer was, in Turin, it always snows during the weekend. Okay, come on. Statistically, it's not that uncommon. That was someone that shouldn't be doing public procurement, honestly. And this is what we needed to achieve, and what we needed to achieve not just for sustainability, resilience, innovation, just we need a better tool to make sure that those operators in the market are actually honest. Thank you.
That was very interesting perspective. I'd like now to turn to Mrs. Ružić, because you had many researches on that subject. So considering these possible changes at the EU level and the discussions we've seen in the Draghi and Letta reports, in which direction do you think the forthcoming reform of the EU Public Procurement Directive will evolve, particularly with regard on sustainability and social responsibility?
Thank you for the question. Yeah, we have seen in Draghi and Letta reports that there is much more emphasis on competitiveness and also on the market integration, which is actually very interesting regarding the sustainable part, which was left in some sort of background. And also this was maybe because of foreign subsidies regulation and also international procurement instrument that came into force right then, because that was last year, at the beginning of last year and at the end of last year. So that is very interesting, but we do now actually see, I think it was 2 months ago that European Parliament has made, adopted a resolution actually on how will sustainable public procurement go in the future. And we have seen that it is very much, they are emphasizing the importance of safeguarding this approach to sustainable public procurement and also the professionalization of public purchases. So I think it will be very interesting to see which side will prevail in the future. Yeah.
Eva, that's a very clear overview of the policy trends. And you both mentioned one thing, and it's the tension between deeper market integration and stronger sustainability commitments. So Professor Caranta, if I may follow up on this, in one of your slides, it was very interesting that you argue for killing the link to the subject matter, suggesting that life cycle cost and integrity should become the guiding concepts instead. Do you think that approach could actually make it easier for contracting authorities to include social or environmental criteria by removing some of the current legal constraints?
Well, what I think is that this link to the subject matter is a constraint that at times in some countries is real. But on the other hand, is something that is just in the mind of contracting authorities. Because, okay, those buying for the state and so on, they are public officials. And they are not entrepreneurs. So if you are a good entrepreneur, you kind of like risk. It's kind of adrenaline. You risk because then you make more money. It doesn't always work. It's called bankruptcy, but it is something that is meaningful. In the public sector, taking risk is normally not really rewarded. You don't get a medal. And that's the reason why, honestly, since the second half of the 19th century, innovation has moved from the public sector to the private sector, often with money from the public sector. But the innovative companies have come from the private sectors. And we have a date, 1866. The Prussians, they are just trashing the Austrians. Why they are trashing the Austrians? Because they have machine guns. Who is making machine guns? Is it the Prussian, the German government? No. Vickers, Browning, these are private companies that they invest in innovation. So it's difficult to ask public servant to be brave, to take risk. And so if we put in the legislation fluffy concepts that might be used against the public servant will say, no, I will not take the risk of adding anything. And honestly, I think this thing about the link to the subject matter is super fluffy. It's so difficult to determine what is linked. And I go back to the idea about the freedom for contracting authorities. So going back, a kind of a military commune de Gravelines, a case by the French Conseil d'État. Well, they were digging out rubbish from the old fortification of Gravelines, and they said, oh, wow, we want long-term unemployed people to do this digging up. And the Conseil d'État will say, oh, well, there is not a link. Well, I think that if we enshrine the freedom of contracting authority to design their contract, in the directive, even today, we have this idea of mixed contract. I can have a contract that is both procurement for works and training of long-term unemployed. So, in a way, is already a possibility. I would to, let's say, make it clear in the directive what is possible, rather than using very fussy concept, hinting that there is something that is not possible. Thank you.
For this very interesting argument, and I agree with you, it ties directly to the fact that many authorities really struggle how to apply social criteria, especially because of this link to the subject matter requirement. Back to Eva. One question, what concrete policy measures could strengthen the impact of social procurement provisions, even if they remain soft law, without overburdening national system?
Yeah, that is a very, very tricky question, because we do have this situation now, and we do see that we don't have actual data on the socially responsible public procurement. So I think in the future, maybe doing something about this measuring system, and then maybe do something about contracting authorities and their obligations to actually apply the usage of socially responsible public procurement when it comes to European institution, to see the exact data of socially responsible procurement in the European Union. That would be ideal.
On that, it was very pragmatic answer, and we are out of time. So if we have some questions from the audience or some comments for our panelists. Yes.
Hi. Speaking from the practitioner side, so I'm an attorney at law. All of the panelists are from the university or scholars, so please don't be offended. Let's take a bottom line, like a recap from panel 1 and 2. When speaking from a micro level from Croatia, we can see that the legal remedies or opportunities for legal remedies, at least from the practitioners, is narrowing. So we have sky-high complainant fees. Reimbursement of costs for the attorneys are practically non-existent. We have in pipeline the new Public Procurement Act, which will enforce some formal steps which you have to imply before making a complaint. And also, there is practically no way of having damages before the court. So that's the bottom line. Then, if we go in micro level, so geopolitically, we can see America first, Europe first, we are building walls. So please don't be offended, but do we or can we even speak about sustainability if we don't have real opportunity for market competition? So we are going in a way that we have one tender and one bid. Is it really, speaking overall, chance for sustainability?
Well, okay, the first part I was a little bit worried. I thought, well, this is for this morning panel. But then you landed. Well, sustainability is really many things. And sustainability doesn't need to be rock bottom competition. Rock bottom competition is going to be bad for social aspect, is going to be bad for other aspects. I think you are saying also about innovation. I don't think that innovation is a problem of how many competitors you do have and things like that. It's about choosing the right procedure. Well, innovation partnership may be a bit difficult, but maybe a competitive dialogue. So my problem is not so much that there is just one bidder. My problem is if you are having an open competition for something that is really very specific, is difficult to describe in the contract documents, and the market has the impression that you have already someone in mind. So, but that's not because someone is trying to pursue competition. Let's be honest, and we are of course missing a lot Christopher Eukins, but the United States are developing most of their weapons, for sure in aviation, with two companies, Boeing and Lockheed Martin. So you don't need 20 plane maker to have your new fighter plane. It's a kind of a very small market. So basically, I understand, and then your pleading is getting more and more difficult to have remedies. It's also the case in other countries, honestly, but maybe here might be a bit more difficult. So damages in Italy, we are kind of generous, and everyone from another country can say, yeah, we know about your, let's say, public deficit. You can't make it much worse just with some damages. But the other part, competition, innovation, let's be honest, innovation is the Chinese, they are innovating a lot, but not because there are European and US bidders, because they are putting a lot of public money on innovation. So I think these are two separate issues, or at least I don't see the link so strongly, but maybe Eva?
Yeah, this is something that I touched upon actually, because we do need to see those differences between member states when it comes to cultural aspects, political aspects, social aspects, and that way we can actually see how those social aspects and green aspects of public procurement can be applied to a certain member state, because something that works for, I don't know, Norway can't work for Croatia, etc. So I think that those differences should be touched upon when we are implementing sustainable criteria in public procurement.
We can finish our panel. Thank you very much to all our speakers for sharing your expertise and perspectives. And thank you to our audience, of course, for active participation and engagement. I hope this session has inspired new ideas and collaborations. And now it's time for coffee break. Enjoying the rest of the conference.
Da ćemo ljudima onda uvek. Ove tri sad, jel? Nisam, samo sam imena. Imam ja, hvala. Da ću na javno prvo. Tako da možemo imati.
Sorry, I've got to go, so I'm just going.
Yeah, a little bit. Interesting. That is a bit better, so I'm gonna have a look at it. No, that was our second. That was our taking the 9 train back, and therefore, no. 24 hours, and the train. No, thanks. Pleasure. Yeah, that's a miracle of the mind. So we've been constantly listening to say that yeah, I hope so. I hope so. Well, that's very ambitious. Yeah. No, that's true. I was very surprised. I'm sorry, I gotta go. So you flex, maybe you give a bunch of stuff. Yeah. That's how we get to that's not what we're saying. He's waiting to lower the mind, but if I say here, so, but I'm sorry, I'm not. Yeah, it was nice meeting you.
Yes, also. So we'll be in touch. Mora pisati. Moraš živjeti. Joj. Malo je. Da. Znaš kaj, evo sad sam mailove otvorila, imam ove svoje mailove i ove paralelno od ministarstva. Znači Maja, pa je sad šta bi jedna osoba tamo trebala raditi? Ne, još nam niko je nacrta. Sad više mogu više.
Hello, let me start by
Radi. Radi. Idemo. Hello, everyone, once again. And we have come to the final part of today's conference. It's my great pleasure to moderate last panel, AI, data, and modernization. We will talk about some of the, I would say, the most dynamic and forward-looking aspects of public procurement, from the power of data, challenges and opportunities of digitalization, and how regulation should support all these processes. Before we move on to the presentations and the panel discussion, let me briefly introduce our speakers. Four well-known experts in public procurement. First, Professor Albert Sanchez-Grails. He's a professor of economic law at the University of Bristol Law School. He specialized in European Union and United Kingdom economic law, including competition law, public procurement, and digital regulation. Then Professor Tunde Tatray from the Corvinus University of Budapest, Institute of Business Economics. She has been playing a leading role in international research projects, for example, international research study on public procurement. Professor Petra Ferk, she's assistant professor for public administration at the Graduate School of Government and European Studies in Slovenia, and one of the founders at the Slovenian Institute of Public-Private Partnership. Petra is also a national correspondent for European Procurement and Public-Private Partnership Law Review. And Associate Professor Pedro Teles, professor in Public Procurement Law at Copenhagen Business School. He's an expert in public procurement regulation, and his recent papers focus on electronic procurement and data, market integration, transparency, cross-border competition, and sustainability. Professor Sanchez couldn't be with us today, but he kindly recorded his presentation. So we will start with the presentation of Professor Sanchez, Digitalizing EU Procurement Law, Priorities and Challenges.
Hello, let me start by thanking the organizers for the opportunity to be here somehow, even if asynchronously, to share a few thoughts on what the digitalization and the embedding or adoption of artificial intelligence in the context of EU procurement law may entail in the context of the review of the directives. And I have framed it in terms of priorities and challenges, but of course, there's a lot to say by way of challenges, not so much by way of priorities, maybe. What I would like to do in these few minutes is to just take a quick, maybe critical look at the state of play of digitalization and even more basically of transition to electronic procurement in the European Union. And I'm sure we're going to hear more about it from colleagues in the roundtable. I explicitly expect Petra and Pedro to say something about it. And then talk about what is the potential that we could hope for, ideally, in adoption of AI and digitalization in a revision of the European directives, and then think clearly about what challenges we're going to be facing and what priorities should lead this process of review. So by way of the state of play, I think it's fair to say that the expected advantages of the full transition to procurement that was pushed for in 2014 are clearly not generalized. And I think that the recent evaluation of the procurement directives that the Commission has published shows that there's a very mixed experience. And this figure that is meant to show us how many of the respondents were in agreement that e-procurement had lowered the administrative burden, even if the Commission presents it in the report as a majority supporting the idea that the burden has been lower. My reading of this data is that really it's not very clear, and there's actually a significant amount of respondents that think that e-procurement made things worse. And a similar thing happens with figure 7 in the report in terms of whether e-procurement accelerated or sped up procurement processes. And again, very mixed view. And we know from the European Court of Auditors report that procurement processes keep getting lengthier and lengthier. So of course, that doesn't mean e-procurement is to blame for the more lengthy procedures, but e-procurement itself has not necessarily cut down the time it takes to conduct a process or simplified the way the process is carried out. So I think that's the starting point. We still have a problem with digitalization of procurement processes, and we are just not really aware of why this is the case. I haven't seen much by way of a deep understanding or a focus of analysis in the Commission's evaluation of why this is the case and what are the pinch points that we should be looking at. So I think that it would be a problem to just either take that we don't really have an issue with digitalization of procurement, because I think we still have it, or to take it that, well, we can just roll out whatever solutions we can imagine without understanding why this continues to be an issue in this process. And I think it's already an important message to say we need to know more about what is being problematic before we can meaningfully try to address it. The other issue that I would like to bring to your attention is, and the rest of my talk is quite heavily referential to this OECD report that was published this summer on transformation of procurement from a digital perspective, is that the report gives us a very good overview of what's happening in the OECD jurisdictions. And it's based on 2024 data, so it's still quite recent, although things are moving quickly in this area. And the report itself stresses what are the main challenges and recommendations that we should take into account. And even if it's formulated for all OECD countries, I think it bears emphasizing that this is directly relevant to the European Union and that this should be an important reference point in the process of reform. And the first thing that I think we need to do, and in this line with the analysis in the report, is that it's more important than ever to have a clear view, a clear vision of what is the true potential of digital technologies in public procurement, and especially of AI. I don't think we can be driven by very abstract calls or claims by technology vendors or by some ungrounded imagination of what could a digital system look like. What I think we need is a very clear, focused, grounded and practical approach to trying to understand what can possibly be done with the technology, and in particular, what are the enablers for this technological deployment to take place. I think we need to start sharing information in a lot more detail, or at least a lot more detail than we have from a public perspective, and make sure that we can go between this excessive piloting or pilotitis of different technologies for different purposes. I think we need to have a common technical baseline agreed by the member states so that we can inform the process of review. I don't think we can have a successful digitalization again if what we do is put mandates in whatever it is, a directive or a regulation going forward, and then the member states need to figure out how to deliver these mandates, whether they are actually deliverable, or how they interact with the other obligations in the rules that we have and in the systems that are already embedded in the member states. So I think we need to have first a much more focused approach to understanding what is the technical horizon of possibility that we are facing here. And I don't think that's really in the plans. I don't think that there's a working group somewhere talking about the specific digital solutions that we have, although maybe the expert groups are doing more than we know from a public information perspective. And I think it's important to think about what is the real potential here, because probably you're all now having heard a lot about what generative AI can do, what agentic AI can do, what all of these technologies are going to help us cover all of these difficulties that we have in processes to make everything a lot more user-friendly and seamless. But the reality is that once you look into it, there's a lot less understanding of how these things can be applied in procurement and a lot less experience in trying to do this. Again, taken from the OECD report, even if AI and machine learning more generally is presented as one of the key digital technologies that countries are experimenting with, and I think we would expect that given everything that we can read and hear about, the reality of things is that if you look at the use cases of why AI and machine learning is being piloted probably or deployed in the different OECD jurisdictions, what we see is that it's mainly about things that are adjacent to procurement, but not during the procurement process. If you look at it, it's basically about categorization of data, but it's not about carrying out selection. It's not about carrying out exclusion. It's not about carrying out evaluation. And it's just about using the data that we sort of have at the interstices of the procurement system, rather than deploying AI for some of the more complicated core tasks. So the first question that we should think about is, can we actually deploy AI for some specific tasks? And if we're going to do that, how we're going to think about the interaction with legal requirements and so on. The other thing that's going to be important is that we should stop sort of hoping that things will work, and we would need to have a very clear view of what is that we want to achieve with AI, and will it be deliverable within the new rules. Otherwise, just drafting abstract AI-friendly rules saying every procedure in the new rules can be deployed by the support with AI, it's just not going to cut it. We're going to need something that is a lot more specific and that tells us what is it we're trying to do and how we're going to facilitate that. From that perspective, then, I think it's important to talk about the challenges. And the reality that comes out of all the different reports, including the OECD's report from this last summer, is that the challenges are not really legal in the sense of the rules allowing for the use of AI or banning it. Most of the challenges have to do with the understanding of the technology, the facilitation of its use, and its embedding. And we see, for example, that the procurement processes are usually not designed thinking about how the users, that is the contracting authorities or the tenders, experience the process or interact with each other along the process. They're just designed as a very administrative procedure that has different steps that need to be followed. But it's important to think about how these things are basically lived by those that are experiencing it, and how could we think about a more user-friendly design in this, which in the end is a two-sided platform. So what could we learn from two-sided platforms in private sectors that facilitate commercial transactions? Can we learn something from them and bring it to the procurement phase? The other issue that is going to be important is what is going to be the legal robustness of some of the digital solutions. And maybe even there are solutions we need to stop talking about because they will never be sufficiently legally robust to merit implementation in procurement. And I'm thinking in particular about generative AI. You have very big questions about whether generative AI will ever reach a level of factuality and accuracy that would make it meaningfully helpful in procurement, rather than creating some suggestions or drafts that need human review, and in the end are going to create lots of duplication of work. So we need to think quite carefully about that, and it would be important to have a significant piece of work led by the European Commission on this issue. We also need to have a data infrastructure that goes well beyond what the forms and the new public procurement data space have created, even if, of course, there have been some advantages coming out of that effort. And I think Tunde will also talk about this in this roundtable. But we need a data infrastructure that is thought for digital procurement. And we need to design digital procurement processes that already create an automated population of databases that then we can use for other things. We need to think quite carefully about the interaction of the data infrastructure, but also its security and so on. We need to also think about the fact that it will not be possible for the member states to simply switch off the systems they have and switch on whatever new systems we imagine, but we're going to be facing significant legacy issues. And the legacy infrastructure is going to be different in every country. The approach of the Interoperable Europe Act of only looking at interoperability when a new solution is implemented can help us here. And if we are going to be requiring member states to deploy new tools or to facilitate the use of new tools, they would need to be fully interoperable. But what that's going to require is then also to think about how we're going to transition into interoperable rules when we have legacy systems that probably look quite different in each of the member states. And also, this is going to be expensive. So we need to think about, is the expense affordable? And if it's affordable, will it be creating the returns that we expect? And then last but definitely not least, we have a big problem with capacity and skills. And we know that professionalization of procurement has always been a problem and that more resource has to be put into it. When we think about digitalization, we'll think about both creating significant centers of excellence of digital procurement, but also having to upskill the whole procurement workforce. And I think in part, the reason why e-procurement hasn't created all of the benefits that could have created is that maybe there's not been sufficient training and upskilling of the procurement workforce, and that has created loads of friction going forward. So if we look at these challenges, one of the first questions that we have is, what does this have to do with the European Commission? And I think if we keep looking at the split of competences traditionally between the Commission and the Member States, loads of the things are going to fall through the cracks because we will have some sort of general EU level mandates or expectations, but the whole implementation is going to be left to the Member States. And I think here what we need is a much more integrated work and collaboration between the European Commission and the Member States, and maybe even if it is going to be a regulation, and Pedro is going to talk about it in this roundtable, then what we will have to have is a much more coordinated, if not top-down, approach to the enforcement and deployment of all of the facilitative mechanisms, including digital, that are going to be required for the regulation to be a success. Now, finally, talking about priorities, I think that the key issue here is that we will have to do loads of things in a short period of time, and it's going to be important to prioritize the effort. All of these priorities are taken from the OECD report, and I just reflect them here and bring them to you because I think they are very important and we need to pay attention to them. I think we need this very clear vision and a very clear ambition, a realistic but ambitious project of what digital procurement should look in the European Union from 2030, which is the timeline that we're looking at. We need to ensure that there's robust institutional leadership and coordination, and I think the Commission has to take a much more active and central role than it has taken so far. I think we need to be clear that we need to build all of these different elements, the data element, the technical infrastructure element, and the people element or skills element, and therefore also invest heavily. And this is going to be expensive, and it's not going to be short term, but it can make a difference in the longer term. But we need to invest in digital infrastructure, digital architecture, and also in promoting this change of digital capabilities and culture. And these are messy processes. This is not going to be fixed by just writing something in a regulation, and it requires a change approach and a project management approach that is going to be much more different than saying implement this by whatever date, or from whatever date just switch it on and it's going to be effective. And the final thing, which also comes from the OECD report, is that we need a lot more digital by design, user-centric approaches to procurement, meaning we cannot create a new set of rules and then think about how do we digitalize them or how do we implement them from a digital perspective, which is largely what has happened so far with the procurement, but we need to flip it. And that's why I think a lot more work should go into thinking these things before we have a proposal from the European Commission at some point next year. Now, again, will this be the way this is going to go? I don't know, but I think that this would be the way to get it right. If we keep trying to do legal-centric transformation, probably we will keep on hitting the same roadblocks and problems going forward. And the conversation is going to be quite similar in 2035 when we take a look back and think about what have we achieved in the first few years of implementation of the new rules. Anyway, thank you for your patience and attention listening to this recording, and I hope that we can have some interaction. Otherwise, if not now, I'm always happy to be contacted online, and I hope that you're enjoying the conference and that the roundtable is going to be successful. Good to see you.
Taking this presentation as a starting point, we will now continue with discussion with related topics in data, digitalization and regulation. We will start with Professor Tetrai. She will be speaking about the impact of European public procurement data, about competition and efficiency. Professor Tetrai, the floor is yours.
Yeah, it will be better. Okay, thank you very much. And thank you for staying with us. I know we've started with remedies, and I was very happy to talk about remedies a lot in the morning. But this is the last topic, the data topic. And I do really hope that in the future it will be at least before the lunch. But it is becoming more and more interesting. And let's say, of course, it was not a critique, but sometimes we do feel that we do not talk enough about data. We do have e-forms, we have public procurement data space, but for what do we use really data in public procurement? May I just explain the e-forms and the public procurement data space from the different perspective to you? When having looked at e-forms, of course, it seems a bit more complex, and it seems that we have to deal a bit more with templates. But behind e-forms, those researchers who deal with data analysis, we are more than happy to, right now, to have those variables which could be connected. It means that right now, based on e-forms, we are able to find the beginning of the procedure, the contract notice, the contract award notice, the end of the procedure, and the contract modification notice, and somewhere the contract execution notice, but right now we should just talk about contract modification. Before e-forms, there was no possibility to do this. Of course, we tried, but the coverage, when we tried to find the beginning and the end of the procedure, was 20% 10 years ago, a little bit later, 40, 50%, but it has never been 100%. And if you have a look at the framework agreements or dynamic purchasing systems, in most of the cases, in terms of these long-term procurement methods, we have no clue what is happening in the European Union countries. What we know is the number of framework agreements and EPSs, but more or less that's it. So in the future, if we will be able to have more structured data, for example, in terms of these long-term procurement methods, maybe we will have enough information about the level of competition in the market. I've just had a look at Sasso Matas's paper, and I like very much because Sasso just criticized a little bit the framework agreements efficiency because they made analysis about framework agreements prices. I think these analyses are more than important. And if we are able to differentiate, in between mini competitions of framework agreements with one supplier or with multiple suppliers, then we will be able to analyze and measure the impact of the usage of these long-term procurement methods. So let's say we are in the middle of this work, but if you just have a look at the power procurement data space, before the power procurement data space, we had just information about power procurement procedures above the EU threshold. Below the EU threshold, most of the countries have been using different data structures, different templates. But it has been changing. And because of the power procurement data space, in the future, the expectation is that most of the countries will use the e-forms logic and the same templates. So we're going to have the same structured data. Most of you are aware of the scoreboard, the public procurement scoreboard. The European Commission and several monitoring bodies measure the level of competition and effectiveness based on the scoreboard's really primitive, very simple indicators. One of the most important indicator is the single bidder indicator. This is the reason why we do not get enough EU money, because, these single bidder indicators are really bad, especially in this part of the world, in the Central Eastern European part. So if we have more information, for example, below the EU threshold, we will be able to compare the level of competition above and below the EU threshold, because in most of our countries, the level of competition is much higher below the EU threshold. So it seems that we can do something better. Maybe it is the flexibility of regulation, or we do not know. But, this is the power of data, and that's why the power procurement data space is quite innovative, because it will make us, will give us the opportunity to measure and to deal with the whole power procurement market data. What we did, and what I would like to show you, is something really fresh. We were working on the evaluation of the directives with the two colleagues of mine, and we wrote a study about the transparency and integrity of public procurement. It is accessible, by the way. It has already been published 2 weeks ago on the European Commission's website. What we decided is that we decided to deal with data from a little bit of a different perspective. So we were trying to deal with the quality of data, the missing data information, and as you can see, if possible, tackling the false information, we try to, let's say, to cover a little bit the fair competition element of the integrity of public procurement. So this is not a study about corruption. This is a study about data integrity, mainly data integrity and transparency. We found several types of trends in the European Union countries. We analyzed all the EU countries' data for 10 years. And it was the first time that we could use the public procurement data space data. So I will show you something very fresh and very new, and I think it will refer to one of the topics in terms of contract modification, which was raised in the morning today. So as you can see, there are, let's say, negative trends in terms of a couple of missing information, but in general, as you will see, we do have a lot of information and necessary information in the notices, or it seems we do have. There are some positive trends that we have much more active contracting authorities. We have more public procurement procedures. We do allow more languages in public procurement. A couple of neutral elements like the publication of contract prices. So it does not really seem too much. May I show you a heat map of the missing information? We were just checking the most important information, which could affect, from our perspective, the competition very much. And as you can see, that it's perfect in terms of procedure type, contract price, or the date of the result, and the duration, more or less the duration of the contract. What is missing and what is very interesting, that it's quite diverse, the awarding criteria type. In several countries, we do not publish information about awarding criteria. Maybe the information is somewhere in the documentation. The question is it transparent or not? Does it affect the competition or not? We thought it does affect the competition because for the first sight, if an economic operator just has a look at the information and he or she does not find it, the representative, then they will not deal with this public procurement procedure if they, without that time and capability to dig deeper and to find information in the documentation. So it was one of the very interesting results what we found, but of course, we tried to dig a little bit deeper. And when checking the different types of countries' activity, we found that if we just have a look at the average number, it seems that the picture is not perfect. But when we group the certain countries, we can find that there are countries where it is a constant problem that they do not publish simply about the contract, about the awarding criteria. And there are countries publish all the information about the contract award criteria. Let's continue something very interesting. I've just mentioned to you that it's perfect. This is a mandatory part of the e-form, so we do publish contract price 100% in the European Union. But if we check the proportionality of those contract prices, which contract prices are below 10 euro, we are above the EU threshold, I would just like to remind you. It seems that in some countries, this is a typical habit. In 20–30% of the published contract prices, that the contracting authorities administrator just put a number, 5, 2, or 7. This is a false information. So when I'm talking about competition and the power of data, I think it's obvious that we do have problems, although we have mandatory fields in the public procurement notices. May I show you something very interesting in terms of the single bidder question? We have the single bidder, as you have already mentioned, the single bidder indicator, and we are measured by this indicator. It seems that the single bidder indicator is the competition indicator. But if we compare the developing countries and developed countries' bid number pattern, we will see something very interesting. In the developed countries, the pattern is much more balanced, which means that the proportionality of, we call it lots, like contracts, the proportionality of contracts with single bid is approximately 20% in terms of 1 bid, 2 bid, 3 bid, 4 or more. In the developing country, the pattern is totally different. We do have in average 30-40% single bid, much less 2 bid procurement procedures and lots, and 3 and more, less and less. So it seems that we do not have enough economic operators, active economic operators in our countries, and we are not able to give birth to new economic operators. So encouraging the existing economic operators will not be enough. So we will not be able to reduce this number just with the motivation of the small and medium-sized enterprises, which enterprises are in the market. This is a very important message, and that's why we try to refresh a little bit, for example, this single bidder indicator, and we try to count together with the direct award, because this is not just a single bid problem. In several countries, developed and developing countries as well, are, well, happy to enlighten the direct award opportunities. In some countries, there is no monitoring behind the direct awards above the EU threshold. So if we count together those direct awards, which have just one invited partner, together with the single bidder procedures, which single bidder procedures are published with notices, then we can find a little bit worse picture in terms of several developed countries too. So this kind of simplification, let's have a look at just the one bid procedures, it's out of date. So that's why we decided to create more indicators, just to show a kind of interesting and wider scope for policymakers when deciding about how to create new punishments against several EU countries. This is what I've just mentioned about the patterns. This is the result of a very interesting research what we have done. And the first in the life of the European Union, we tried to discover a little bit more about the success of public procurement procedures. This is an efficiency issue. If we just work very hard and finally we do not have enough bidders, we do not have at all valid bids, or we do not have bidders at all, then, you know, it is a failure, and this is a waste of time, a very, very inefficient and very costly activity from the contracting authority side, and of course from the bidder side as well. And we can see that in several EU countries, 10, 20, 25% of lots of potential contracts are unsuccessful. This is a waste of money and time in 10, 20, 25% of the time and of course of the budget of these contracting authorities. This is a very important message. You know, how to translate it into the regulation, what to do with it, it's very, very hard to tell. But I think when we raised this issue, it was one of the most interesting, what was, let's say, referred from the first moment, because it was brand new and, well, let's say, we did not deal with it beforehand when evaluating the directives. Coming back to the framework agreement question, we decided not just to count the existing very, very simple data in terms of framework agreements, but we tried to differentiate a little bit. And we tried to know if contracting authorities use framework agreements with multiple suppliers, or they just use it, let's say, to close the market with one supplier for a longer duration. So we were dealing with the average durations of framework agreements concerning all the EU countries, and of course differentiated if those framework agreements are signed with multiple suppliers or single suppliers. And we try to, let's say, dig a little bit deeper, and we try to analyze if the very big market players like center purchasing bodies use framework agreements for opening the market and opening the competition with signing the contracts with multiple suppliers or with single suppliers. And what we found is that in some member states, it's typical 80%, 70-80% framework agreements are signed by just a single supplier, and the average duration is more than 30 months in those countries. And there are countries where the CPPs, the biggest market players, are 80-90% just signed framework agreements with single supplier. I do not want to say, of course, as an economist and as a lawyer, that framework agreement is forbidden with a single supplier. The question is, if we overuse the framework agreements with one supplier, does it have an effect on the competition? And it has. Maybe we can open the framework agreement a little bit later for newcomers, and let's say we have an opportunity to change the regulation and to find a way in between dynamic purchasing system and framework agreements, as it is in the US FAR regulation. Or we let it go as it is, but maybe it will not help to market players. And last but not least, this is the contract modification indicator. We created 2 contract modification type indicators. This is coming from the Power Procurement data space based on e-forms. We were just counting the numbers of notices, Power Procurement procedures, and the related numbers of contract modification notices. A very, very simple information and data. And the first time we could find a connection in between notices and contract modifications. And you can see the red is the contract modification. Then in several countries, it does not exist. Of course, we've heard from François that yes, the French regulation is different, but there are so many different regulations in the EU. But it seems that the contract modification is not the most transparent part of public procurement, although it should have been part of the transparency policy, because this is the reason why we have a mandatory public procurement notice for contract modification. So there are countries which simply do not publish any information about contract modification. And there are countries which are very active and very happy to publish those information, and maybe there are remedies and there are arbitration board procedures and several appeals because of publishing this information. So sometimes it's working, sometimes not, but this is an interesting message, how we do not publish information, although this is mandatory. So I think this evaluation was interesting enough. Of course, we received so many attacks and a lot of arguments. Okay, it's not an easy life to be a researcher, but I do think finally it will have an impact on the measurement of efficiency and competition. And we do hope that we will be able to support those countries who would love to get more EU funds, and of course, who would love to get more information about their public procurement market. Thank you very much for your attention.
Thank you very much, Professor Tetre, for this, I would say, a very inspiring presentation on data and the importance of structured data and the data we can rely on. So it was very, very good. It's very, very inspiring, really. And when we talk about inspiration and data, sometimes I cannot say it in the same sentence, but you made it. So thank you very much. It's very interesting. And now we will turn to the digital transformation. The Professor Petra Perk will talk about digital transformation in public procurement, current state and future directions.
Thank you. Good afternoon. Before we start, let me start with a question. Are you excited about electronic and digital procurement? Please raise your hands if you are. Okay, less than 10. I will repeat. Are you excited about electronic and digital procurement? Even less. Even less arms. Okay, I can understand. I can feel your pain. Okay, those 10 of you who raised your hands, now we are going to check if you are more or less excited about the digital procurement as you were 10 years ago. So please raise your hands if you are more excited today as you were 10 years ago. Okay. And if you're less excited? Okay. So those 10 of you who were more excited, who are excited are more excited as 10 years ago. So that makes hope. I would say that makes a lot of hope. So I'm one of those who was very, very excited about electronic and digital procurement. I still am, but I'm a bit more realistic. Let me explain why. When Marco invited me for presentation and I was started doing this presentation, I checked my slides, 10 years old presentations, and I could simply take one and use it here, and everything still is as it was. I hope that it will not change much. I hope it will change more in next 10 years. I have here QR code to Mentimeter. I hope you can scan it now, but it will be repeated later because I have some Mentimeter questions at the end. Before I start my presentation, I would like to give a little bit of background of what I do so you will understand better why I will approach this issue from more practical perspective from day-to-day procurement. 10 years ago, as being one of the founders of Institute for Public-Private Partnership, 30% of our work is research, but 70% of our work is supporting contracting authorities in complex public procurement procedures and mostly concessions. So we were really seeing electronic and digital procurement as we see it today, digital transformation, meaning 4.0 procurement. And we were looking for a solution who would support us. I must say we were a little bit disappointed seeing the directives, only 4 phases being obligatory, and we knew that this is the solution we are going to have. So for our own consulting company, we were looking for a solution which would support our procedures basically end to end. So we invested our own savings into localizing one of the global procurement platforms to Slovenia. First, we were considering developing the platform by ourselves. So we soon identified we don't have enough funds because we are not government. My husband even traveled to India so that was one stage. So we thought we could do it this way. And then, so we said, okay, from the scratch, it will not work. So we started to identify off-the-shelf solutions, and we did diligent benchmarking. So we identified a company who was willing to localize its solution to Slovenia. It was, according to Gartner at that time, a top 3 companies for globally for electronic public procurement in public sector and top 5 companies in private sector. It took 3 persons for 9 months approximately along our regular job to localize the solution. So today we have end-to-end platform, digital by default, operating in 5 languages, artificial intelligence being implemented, but we are still not there where we would like to be. We don't have such a solution as we hoped to have it because we don't have digital data, we don't have structured data. And I'm not saying that from the transparency and monitoring perspective, but basically from the day-to-day procurement. So when we are evaluating where we are today, we have to accept where we are, and then we can start considering how we would be able to move forward. This slide I think we are all aware of reality that European procurement is about something more. It's not just about the efficient use of public spending. So in European Union, we have to be more careful. So other geographies have much simpler work to do. So EU public procurement is about to eliminate practices hindering or directly or indirectly hindering economic operators from other member states to approach the biggest contracts. So from this perspective, we also have to be aware of the legal basis for adoption of the directives, or, you know, Pedro will be talking more later about regulation. And here there is basically a question what the European Union can do and what member states or diligent contracting authorities can do by themselves. But the result still is that we have, you know, still approximately 5% of cross-border procurement, which is not much. So what is mandatory and legal basis for electronic procurement? I think we all know Article 22 of Classical Directive, similar provision in Infrastructural Directive, and very important, it is not obligatory according to Concessions Directive. I think that's a pity, and this was basically one of the main reasons why we also were looking for a solution supporting concessions. We thought that's very important also to protect ourselves as advisors. What was new in 2014 directives was electronic submission of bids. Basically, that was the only step which was new in pre-award phase. In post-award phases, it was electronic invoicing, but first two steps were already there. So, and this is something what we have to have in mind when we are talking, when we are discussing, you know, what to expect next year, what we now have. What I think it's as a very important, that plays a very important role, Albert nicely said, legal robustness of the systems is how to ensure integrity of the data. You know, Tunde talked a lot about the data that we need to have, but we have to somehow assure integrity of the data for the monitoring purposes, for the transparency purposes, but also for the day-to-day procurement to protect the both parties to the procurement. So the directive has foreseen encryption, timestamping, and electronic signatures as main tools to assure integrity of the data. So it was foreseen that Commission will adopt delegated acts, and you know that Commission shall also carefully consider the costs when adopting delegated acts and standards. I think this is really one of the main reasons, you know, why we have situations as we have, because electronic systems cost a lot of money. So I do part of my job to pay the bills is doing feasibility studies for concessions, for PPPs. And you know, if you do feasibility study for any IT project, you know you will have to change the hardware every 5 years. This is costly. You need to consider operational costs, you know. So considering all these costs related with all the standards, you know, it's really difficult to assure platforms which are advanced. So we don't really have the data about how many electronic procurement platforms there are in the Europe. Some say 100, 120, 150 of like proper platforms covering majority or all of the procedures. Some say 250, 300 covering also partial parts of procedure, maybe only direct awards, maybe, you know, documentary systems, having some functionalities or similarly. But basically, we don't extinguish among them. We don't have any standards, minimum standards, which would have to be fulfilled for the platform to be considered safe, you know, because this is a lot of data being on the platform, and in the future, we are going to have even more data on the platforms. So I hope we will see in the next directives at least minimum standards that will have to be assured. I hope, I can still hope, you know, for those systems, because basically now we all systems are treated the same. All evaluators and authors were critical on what happened in last 10 years. Pedro is writing about last decade. So Albert already addressed the issue of what we should do, what OECD and European Commission identified as steps forward. But we all have to agree with Tunde that we need more data, we need more structured data. So this is one of my slides. It's 10 years old. And 4.0 electronic procurement, this is how I saw it, you know, 10 years ago. And this is what I was looking for. And when we say, like Tunde was discussing before, award criteria, we don't know what is award criteria and we don't know what is behind it, you know, for transparency issue. I see that this is really a lost opportunity for contracting authorities. If we would have award criteria in structured manner, you know, how I saw digital platforms or how I see it is like being procurement officer, I need to buy vehicles, you know, I go to the platform, they suggest me what to do, which award criteria, you know, who did what, you know. So basically, you know, I have like bulletproof solution guiding me through the procedure. So I really have time to think on the quality. So what I would expect to see from the European Commission is, you know, I was a bit surprised that today on the I think it was the third panel, nobody mentioned Buy-European initiative, which was basically the only thing you did. Sorry, I didn't hear, but this was basically the only thing that the President of European Commission addressed at the early speech, referring to the directives that we are going to implement by European criteria to the new directives. You know, so I'm thinking, why are we so naive to implement by European? If we could implement tools enabling us evaluate carbon footprint if we buy water in plastic bottle instead of, you know, recycled, reusable glass bottle. I don't know, bringing food from next village or over the seas, you know, and we would be using green and sustainable criteria, evaluating tools, and we could do it wisely, you know, by using the instruments that we are advocating. And, you know, everything is already there. Everything can already be calculated, but it's just not implemented to the procurement. So these are the tools that I hope that we are going to see, that they are going to be developed, and that we are going to be, you know, wiser. I don't know really, it's probably, I should use some politically more acceptable word as naive, but I really hope that we will not be naive and that Europe, we will still show the way how to have an open market and really, you know, wisely do what we are talking. And this is what I hope that we will see. So, of course, We did some step forward with electronic forms and public procurement data space, and I hope we will also move into that direction. So European Commission is still using both words, digitalization and electronic procurement interchangeably, but OECD changed the vocabulary, so they are talking about digitizing, digitalizing, digital transformation, you know, some sort of I sometimes have a feeling that it's a little bit of an excuse for what we have, but basically this is where we are. So I would not like to guess where we are going, so I hope to get your opinion. But here on this slide, I basically tried to summarize different, I cannot even say functionalities or modules of the end-to-end digital by default procurement. Basically everything what is from 2.0, 4.0 procurement. So red are the most important steps that we have now electronic, and this is obligatory. So in blue color are the main steps, functionalities of end-to-end procurement, and additionally with green are identified some of the main characteristics of 4.0 solutions, basically what we are addressing, digital transformation. So I don't think, especially from what Sasha, Michael and Sasha said, you know, when the Commission asked if planning stage, you know, as the first stage of end-to-end procurement will be mandatory, I don't dare to hope that we will have that. But we can see if we compare what is red, what we have now, and what is in, yes, what is in blue and green, what is not yet mandatory. There is a lot of work to be done. It doesn't mean that some contracting authorities or some member states are not doing it in electronically, but it's just not obligatory, so that means that not everybody are doing it. So this is the QR code. If you would scan it, I will wait for, yeah. I already expressed my view, what I hope in what we will have. Tunde was skeptical, yeah, okay. I have 2 questions for you now. Okay, do you all have the code? Yeah, you have it? Okay. What are the 3 main barriers to full digital transformation of public procurement in your country? So I will be able to give you what? Okay. Is it working? No. Okay, it's working. Okay. You have to start voting so that it works. You can choose up to 3 options, not just one. I think these were the 3 main reasons. Yes, the skills, and we are all aware. This is also 10 years old slide. I kept it. It's in a bit different words, written the same in OECD good practices report. But last slide, and I think this is the most important slide, a very important message. What do we think that should be top priorities of the new public procurement directives? So I will not be reading all the possibilities. I think it's easier for you if you read it because there are a lot of them. Oh. Don't have? Okay. I was actually thinking to do other, but yeah. But I would have, what is it? Okay, so it's simplification. We are all hoping on simplification. Change as little as possible. I think that's a very important option. Yes. So these are our top choices that we have chosen. So let's hope that we will head into that direction. So thank you.
Thank you, Professor Ferk, for this interesting presentation and excellent overview of how digitalization can shape the evolution in procurement. And now we are moving to a next dimension, regulation. Please welcome Professor Pedro Teles. He will be talking about regulation as the way forward.
Thank you. Thank you very much. Let me just get me some water before I start. So I feel like the odd one out. Marco didn't tell me that this was a session about data, because if you told me initial stuff, I would have submitted something different. So, okay. So I feel like someone that is gate crashing a party that is not my party. Anyway, with that said, with that out of the way, it does. Now, I also add an original title and an original presentation that I had prepared, but something happened by the time, or between the time of me preparing the presentation and actually today. And that was the submission or the publication by the European Commission of its work program for 2026, where it states quite clearly that it's going to put forward a public procurement act. Now, if the rest of my presentation comes across as a little bit someone that is taking a victory lap, I hope that is not too much of a victory lap, because, sorry? It's a bit early because we never know how this is going to end up at the end. But for now, what this indicates is that the Commission is planning to put forward a regulation for public procurement instead of a directive. Now, you'll notice here as well something important, which is the actual legal basis for this new regulation. It's again Article 114 of the treaty. Now, with that in mind, again, what is the job to be done for EU public procurement rules? Why do they exist? Why were they created in the first place, and why they are still what they are today? And that is, as you were using my slide, my image throughout the day, I saw it. It is to create an EU public market or EU market for public procurement. It's to bring down those barriers between the member states so that we have an internal market in public procurement. If that is the case, if that is the job to be done, have the directives a successive rounds of directives been successful in achieving this goal? And the answer is not really. Not really. When you look at direct cross-border procurement, i.e. the contracts that are won by foreign bidders in a given member state, we see that in the 1960s, and yes, I found data from the 1960s, we had a success rate back then of 1 to 2%. And nowadays, in the 2010s, we have a success rate between 2 and 5%, depending on the study that you're looking at. And the most recent is the one from the European Court of Auditors in 2023. So we've moved, after 50 years of directives, successive rounds of directives, we've moved from 1 to 2% of direct cross-border procurement to 2 to 5%. I know what is my conclusion about this state of affairs. But what we also had recently was the Commission in its review or in its analysis of the current round of directives coming up stating that there is a relatively low level of direct cross-border procurement after the entry into application of the directives. Now, until recently, the Commission really liked to mention not direct cross-border procurement, but a different figure, which was indirect cross-border procurement. However, you don't really see that in the evaluation. And when you look at what the Commission is saying publicly, on LinkedIn, again, on LinkedIn, we have a statement that was posted by one of the DGs from the European Commission saying that direct cross-border participation within the EU remains limited. And this was a publication or a post not only in this particular account, but also posted in the account of another DG of the European Commission. So the European Commission view at this moment in time seems to be aligned with mine. For the first time in my career, I've been saying for many, many years that the directives have been unsuccessful. They failed at their job to be done. And now the Commission, in its Commission speak, appears to be recognizing that fact, because they've dropped the idea that we check the success of the directives vis-a-vis the internal market by looking at indirect cross-border. No, it's direct cross-border. And yes, we recognize that the results are not great. Thank you. Thank you, Commission. Thank you. After so many years of being, hearing that I'm wrong and it doesn't make any sense, it feels good. It feels good to see the Commission recognize it in its own way, in the way that the Commission does this set of affairs. Now, the Commission appears to be proposing a regulation instead of a directive, and you might think, well, that's not really common. That's not something that happens a lot. And I'll say to you, no, actually, it does. It does happen quite, not every year, but it happens with a degree of occurrence that is not just a once in a blue moon event. So we have a number of directives that were transformed into regulations over the last 15 years. So we've got 8, I think, on this page. We're going to have another 8 in the next one. But what is interesting here is the second column that I have. On the second, third, and fourth columns, I've included my coding of the reasons why this transition from a directive to a regulation occurred. And by far, the most common reason was the directive that was there before and transformed into a regulation was not actually achieving the goals that led to its enactment. It's a recognition of failure. So the Commission has, over time, in other areas, been quite adept at actually recognizing the failure of directives. So this is not new. You shouldn't be afraid that this is happening in procurement, because actually it happens every so often all across the regulatory space of your law. So that is the first point that we shouldn't be afraid of. The second one is the Court of Justice last year and early this year actually threw a very large bomb, almost like in a cartoon fashion, into the hands of the Commission with the Collin and the Qingdao cases. I had to talk about them. So with these cases, what the court has done is, in its own way as well, which is very blunt, prods and try to convince the Commission to get going and actually regulate third country access into EU public procurement by parking by parking public procurement within the sphere of an exclusive competence of the union, in this case, the common commercial policy, what it is doing is saying, this is so serious that Commission, you need to do something about it. So I guess, and I don't have any insider information, that this might have been another reason why the Commission ended up moving from a directive to regulation, because you cannot really solve calling with a directive. That is my view and my interpretation. So I think that is undoable. Then we have as well a recognition. Roberto mentioned this earlier on very well. We have 60 or 70 sectorial pieces of legislation outside of procurement that are influencing procurement. Some of them, more than sectorial, they are transversal, like the foreign subsidies regulation or the international procurement instrument that we also heard about earlier today. But then we have new stuff like the EADS regulation, the recast version that is going to come into force and change how you can have access to procurement. Albert mentioned as well the Interoperable Europe Act, which sits also outside of procurement, but will shape and constrain how procurement operates. All this is being done via a regulation, not by directives, because there's a recognition that if you really want to change practice, you're not going to get that with a directive. So what are the benefits for this move? The first one, and I think the most important one, is that it opens up a new regulatory equilibrium. What do I mean by this? Basically, we've been doing procurement or regulating procurement the same way for 60 years. By changing the choice of legislative instrument, and the stakes associated with the regulation are much higher than the stakes associated with the directive, because you don't have the buffer of the national law to paint over the cracks of the secondary legislation. We actually are forcing the EU institutions to take this legislative process in a much more serious way than if they were just redoing a new directive. So this means that there is more space, I think, and probably more openness to really try and address the key legal issues that we have in procurement at the legislative state within the EU, instead of kicking down the can and saying, okay, actually, the member states then can solve this, and if they can't, then the Court of Justice will solve it by case law. So this actually forces this change in the behavior of the different institutions that are going to be involved in this legislative process. That is, I think, is the main advantage. The second one is, by doing this via regulation, what you're doing as well is standardizing rules and probably practices too. So you move from just harmonizing, which is very disharmonizing. When you try to harmonize something, there's still a degree of disharmonization, and you actually try to move that harmonization to more unification, which is terrifying for people. It is absolutely terrifying for people. But if you really want to achieve a practice that is more or less consistent across the union, then you need to move from mere harmonization to more unification than we have at the moment. The immediate consequence here is that you're going to be solving legal system inconsistencies. You're going to solve the problem of, or at least mitigate it very, very significantly, the problem of a certain legal concept being transposed, implemented, and addressed in a certain way in a member state that is ever so slightly different from another member state. So you end up with that internal inconsistency on the union, that the same legal concept means something that is ever slightly so different in each member state. So that problem, again, is not going to be fully solved, but can be mitigated. Finally, the other advantage here is provide procurement and imbue procurement with a degree of seriousness and importance that it currently lacks, because it's just a directive or 3 directives. Now, if you're regulating this via a regulation instead of a directive, then you're actually making it more visible and more serious. The key example here for me here is the GDPR. If you look at the General Data Protection Regulation, which people think that it's a great development within the EU approach to how to deal with the protection of data, as it happens, from a substantive perspective, the rules are more or less the same. But beforehand, there was a directive, and now it's a regulation, and the enforcement of the regulation is done very differently. So with the national regulators, with more powers, with significant consequences for non-compliance with the GDPR, we now have a much clear, a much more compliant with legal regime than we had ever had with the previous directive. So the obligations are the same or similar, it's just the seriousness and the consequences has changed. So I think that could happen in procurement as well. Now, I am a researcher, I'm not an activist. So when I'm putting myself out there and putting my ideas out there, it's important not only to say, well, this is all good and great, my ideas are fantastic. No, they also carry drawbacks and they carry issues and problems, and it's important to address them. The first one, I think, is that the bad regulation is worse than a bad directive. If I'm wrong and the EU institutions fumble the dance and the negotiation of this new piece of legislation, we may end up with a much worse outcome because we now are all stuck with the regulation instead of having the buffer of the directive. And that is certainly a possibility. That is certainly a possibility. Then what research tells us is that if you really force this unification of the rules, then actually you may, under certain circumstances, reduce compliance and increase the divergence at the practical level. Not necessarily at the national level, but the practical level, in this case, of contracting authorities. And then finally, we need to be respectful, or we need to recognize that a new piece of legislation is not going to magically solve all our problems. No, it's not changing the rules that changes practice or changes institutions. Changing the rules will help somewhat, but at the end of the day, you need to change a lot more than that. And changing the rules is the easy bit. It's not the difficult bit. The difficult bit is actually what comes after, changing the culture, changing the institutions, changing the organizations, and changing the practice. Thank you very much.
Thank you very much, Professor Telles, for clearly outline the possible reasons why regulation and not a directive, but also the potential risks of this, I would say. After this excellent presentation, it's time now for a final panel of today. But before I start with my question, I would give the opportunity for the audience maybe to say a short comment or a question. I saw the colleague there has a question, so I will put you the mic. Okay. Mm-hmm.
Surprise, surprise, I have a question. Well, not just question, maybe like a final remark. So we have fourth panel regarding the digitalization overall, and the first panel was regarding the remedies. So let's maybe have a naive or cartoonish or utopistic question. Do you see maybe in 10, 15 or somewhere in future maybe mechanism regarding IE? So in first panel we had question regarding the private enforcement. Then we talked about public enforcement in remedies. We also talked about civil society. Do you see somewhere in future kind of platform? So we heard from Professor Telles regarding the regulations. Professor Tunde talked about data. We hear about platform. So do you see in combine everything somewhere in future, i.e. remedies, something?
But right now, there are AI solutions in Remedy. because this is a kind of defense, especially for the remedy bodies when they feed their AI with their decisions, not just in general, with all the knowledge of the word, and it helps them to know, what happened before, what would be the decision in terms of several questions. Of course, right now we are at the very beginning, but it's happening, and I saw it in Finland. I saw it in Albania, for example. So when Albania would like to, let's say, do their best to show the better picture about the public procurement, then the first development, what they were initiated, is the AI in the remedy system, with the usage of AI. So I think even in Hungary it is happening that the State Audit Office started to develop a solution. And of course they use the arbitration board's decisions and would like to identify, based on those decisions, the contracting authorities, the hidden contracting authorities, the bodies governed by public law. You can imagine what is happening when the investigation has started based on the usage of AI. So I think we are in. And yes, I do think then if we have more BCGO cases, it will be better, but some of the cases are contradictive. So let's say we will see what AI will simulate based on those contradictive decisions. So it will not help. So we need human beings and we need their help. But I think it's a kind of defense even for the stakeholders using AI.
I think it's inevitable. It will, like, yeah, I asked the same question 2 weeks ago to one of the judges at the European Court of Justice, and he replied, I would say the same, but it's very sensitive, because you have to be within the closed system, and as Tunde said, there can be different decisions. So at the end, you have to really, you have to be careful. But we will use it in all of the aspects. I think this cannot be differently.
Anyone else? Yes, please.
Pedro, how come can you believe in the European Commission, that the European Commission is able to prepare good EU regulation? And that's a really serious question, notwithstanding how much I don't believe in that. Because take the example of Colin, right? We should basically blame the European Commission for the whole mess, because the European Commission was not able to propose anything for years that would basically clear up the situation, was not able to react. When we are talking about basically any specific topic about public procurement, exclusion grants, modifications, rejection of bids, there are doubts how to interpret all those things. And then we ask the Court of Justice to help us with these problems, but then we blame the Court of Justice where we are, and that it goes as a politician, not as a court, etc. So it looks like that. Basically, as you said, really, I mean, concurring with that, bad regulation is much worse than even bad directives. But for me, this is totally sufficient argument against regulation, because I don't believe the European Commission could prepare good regulation.
Okay, I've got a few comments to that. Piotr, thank you very much. The first one is, it sounds weird for me to to defend the Commission because that's not something that I usually do. In fact, I tend to be in the bad books of the Commission for doing the opposite. I would say that we need to share the blame on about the state of legislative processes within the EU across the EU institutions. So it's not only the Commission, but also the Council and also the Parliament. Because remember, it's the Commission that puts the draft on the table, but the co-legislators are the Council and also the European Parliament. So I think it's unfair to park the responsibility only at the feet of the Commission. Then there's a more fundamental question, which is if we don't believe that institutions can do a good job, then effectively, without realizing, we are putting the writing on the wall for the European Union as a project, which is the European Union as a project exists because is a machinery that spits out legislation to govern, the competencies that were given to it by the member states. If we're now already at the point that we don't think the EU institutions are able to do a decent job, then probably the Brexiteers were right and I was wrong. So I prefer to see this as an opportunity, although I recognize that is a challenge and a risk. Regarding your comment about the Court of Justice, bearing in mind what I heard publicly in March, a judge from the Court of Justice that was not involved in the decision, but she said this with a huge smile on her face, that Colin is the first example of a decision or judgment by the court that shows political realism. The words she used were political realism. So this is an activist court, and this was the Grand Chamber, right? This is an activist court going well beyond what is supposed to be its role. Its role is to tell us, this is the correct interpretation of the EU law. This is what EU law means. It's not to actually send messages via its judgments to the Commission, say, Commission, get your act together to regulate this area. So Colin is a good example, a very good example of what the Court of Justice, in my view, should not be doing, and it's not mandated to do. Now, historically, the Court of Justice has done that at inflection points. So we may look in the future, look backwards more generously than I'm looking at now going through the process.
I think that regulation would solve a couple of solutions, and they would be good solution for the goals that European Commission is trying to achieve. I think also one of the issues which we have is interoperability of system, and this is where we could use or follow the approach, as it was Pedro already mentioned, EIDAS, connecting national schemes, and this would be like a good solution, and it would ease much of the Commission's work. But I think that the regulation, like we always have to be careful with procurement, because we have to distinguish between what are EU objectives of procurement and what are national objectives, So basically there is a line. So member states, I think that for the member states might be harder if we will have regulation, because, okay, that will be then mandatory. They don't need to transpose, but now member state with same legislative instrument, some of them did more on different fields, as it was said, and this might be more difficult for member states if we will have a regulation, but it's not impossible. So yeah.
Thank you. Any question or comment? No? Okay. Then I will continue with the... Professor, do you want to? Okay. Yeah, okay. 5 minutes. 5 minutes. Yes. 5 minutes, because you answered to some of my questions. So 1 or 2 questions, and we can go. Like Daniela, the other Daniela said before. Just a short question for Professor Tetray. You highlighted the role of data and competition in your presentation. And one question, can we really measure competition in public procurement? Because when we talk about the competition, the first thing that that cross our mind is the number of bids, the number of bidders. But is this really so simple?
That's a very good question. I believe so. The World Bank made a study about competition as part of this evaluation work. I do not want to simplify because Michael Fruman published a lot in LinkedIn, his LinkedIn posts, and may I just really refer to it. One of the messages of this World Bank study is that the problem is not as huge, so it's okay. Coming from the World Bank, I can imagine that, yes, of course, there are so many opportunities how to measure competition. And from that perspective, how they developed a couple of indicators, it seems like, you know, it's compared to other countries of the world, it's quite okay. But from the perspective, and we have so many small countries in the EU, and we would like to defend our internal markets. And of course, parallel, we would be more than happy to have much more economic operators in our markets. There are so many contradictive purposes. So when we measure our competition in our countries, maybe the picture is different than the World Bank's picture. So I do believe so that we're able to measure. But I saw so many simplification in guidelines like, oh, the average number of bids, it's 12, so it's more than 10, so it's okay. But, you know, if you have even one procedure with 1,000 bidders, it means that it will affect all the other results, because the average will be quite high if you have a couple of really many bidder procedures. So I do think that we have to differentiate. We have to deal with the single bidder, direct award, mean, median, and so many very simple statistical solutions we can use. And then we will be able to decide how to present it for those politicians who will somehow simplify the simplified data. So you can imagine what is going to happen. So that is the real risk.
Thank you very much. So it's not so simple. Okay, thank you. And Professor Ferk, in your presentation, you clearly distinguished between electronic process and digital transformation. It's not the same thing, as we know. But what is the key step that could move public procurement from electronic compliance to real digital transformation? If you could just point out one or two things.
Well, it turned out that this panel was about the data, you know, so it was not my idea as well, but I think that would be moving from document exchange to data management in day-to-day procurement, how to do procurement, and also for the transparency. And we will achieve that by implementing more in the next directives or regulations, the digital by default approach. But I would also make one comment, because Slovenia is always, you know, we have an issue with single bid procedures, and I see it a little bit differently because I'm also a practitioner. We are so many times so happy to receive at least one bid. You know, our especially construction sector was severely damaged during 2008 crisis. And it's really difficult, you know, you don't get contractors, and a lot of times we are really happy to at least have one bid. And also, you know, from the national perspective and from EU perspective, the procurement should be giving the chance to economic operators to participate, but we cannot force them to participate. public procurement will always be more difficult. There will be more steps. It's a procedure than, you know, giving offer to private sector, you know, business to business. And if companies have enough work with the private sector, you know, so then often they don't decide for
They
public
don't
sector.
choose
They
to
don't
compete
choose.
in public procurement.
Exactly.
Of course.
So, you know, we have to be aware of this reality.
Thank you very much.
Can I just come on that, even though I was not allowed to talk about data? I mean, the fundamental problem we have is that the current system, electronic procurement system in the EU, simply repeats what was done in paper and now gets done online. So in 2014, we missed the opportunity to actually transform it and design a system, as Albert was saying correctly. A good electronic procurement system needs to be digital by design. And this was digital by accident and not by design. Now, there are reasons for that, and I was told those reasons on the back of a cab, so that's the story I need to tell you, that I've not finished, the story behind it. But that is the fundamental problem, is that we ended up, when it comes to data, for example, we ended up with a notice-based system. The idea of notices goes back to times immemorial. The idea that you would affix a piece of paper outside the local authority to announce that the contract would be available. And we imported that logic of the system, and we're trying to capture data digitally by using the same mental framework that was designed in the 18th and the 19th century, for example, in France, with the procurement of public works in France. So it just doesn't, it's not appropriate. So we need to move from a notice-based system to capture data to a transaction-based system to capture the data. Now, the problem of the mistake of 2014 is because of the sunk costs in national systems, in those 250 electronic platforms, in those different ways of solving the same problem. Now you going to have a lot of resistance to try and solve the problem that was created back in 2014. And it's a lot more expensive.
Thank you very much. Since this is a panel about data and digitalization, I don't have additional question for regulation. If someone has a question, no, I'm joking a little bit, but we are slightly running of time, and I would like you to thank all of you once again for really inspiring presentations. I was a little bit worried because our panel is the final panel of today. It's late afternoon. I thought everyone will be sleepy, but if someone was sleepy after your presentations and discussions, I think it's not sleepy anymore. So thank you very, very much once again. And now for the end, the few words from our organizers. And thank you very much to the organizers for bringing all of you together here.
Well, all I can say after such an eventful day is thank you. First of all, thank you to all of our panelists, to all of our speakers. Thank you for agreeing to join us. And thank you for your really insightful presentations. Thank you to all of you in the audience for bearing with us, for joining us. And I'd like to extend a special thank you to DECOM, because Maya and I were talking about organizing a conference like this for a long time, I believe, a couple of years definitely. And the ball started rolling after the Copenhagen conference, when we called each other and we said we need to have something like this in Zagreb. And the Copenhagen conference was really brilliant, and hopefully we came close with, I know we came close with the level of speakers, which were phenomenal, but I hope we came close with the program we put together. So nothing more from me, just a big thank you to all of you that joined us today. Thank you.
Yeah, and just thank you, Marco, for this. Thank you. And I will not repeat after Marco about thanking our panelists and our guests for coming here and joining us today. But I will use this opportunity to thank the University of Law and the Faculty of Law, University of Zagreb and Faculty of Law for getting into this story. And I hope that this is just a start of something we will do years and years along. And I would like to thank my team from the State Commission and all our people from the Commission for helping us in organizing this, because these are people who are solving appeals all the time and they're during the day, and they're doing this on the side. So thank you so much, guys. I really appreciate this. Have a nice rest of your stay in Zagreb for our international guests, and see you, the ones who are here from Croatia. Bye.
Again, that's hot. I'm following you. So if I see something, so yeah, but it's we will organize something next year. We'll see what's going on. Yes, thank you for coming.
Check it. Aha, also was wieder.
Photo panel. And also my.
Mislim, ako se trebate odmoriti, odite, stignete se i do hotela.
Poslao sam ja link svima, ono da...
Da.
Gdje...
Ali možemo otići. Da.